Hello, everyone. My name is Andrew. I'm the founder and owner of IBIS Prep, and today is class number 30 of the Florida Bar Complete Crash Course. It's been an absolute honor to teach this course and to outfox all the other students who are taking this exam. So we're going to begin today by working on the questionnaires. And I'm just messing with you guys. I'm going to change my avatar to me, the one and only. I don't know if you prefer me as a fox, let me know. I'm happy to change back. I kind of feel more confident as a fox. It's like I don't know, superpower. But we're gonna start with the review of the questionnaires. So let's go with the questionnaires and see if we can really master them. So these blank essay questionnaires, it says try to memorize these. So I'd love to have some people step up and see if they can memorize them. Do I have any volunteers? If you want, you could put an avatar on your face and be an animal, or you can have your camera off. The volunteer list is quiet, very quiet.
I can do one if you want.
Let's go, and my rave buddy. Okay, are you at the gym right now? We're gonna let her prepare. See, she went. I told you we should get warmed up before you start a test. So she's getting warmed up right now, getting into her.
I was just moving because my friend was studying and I don't want to be loud around her.
No, is she studying for the bar?
Mm-hmm.
She doesn't want to join the class.
No, she's
All right.
reading essays. She went to Harvard. She's like worried she's gonna fail. I'm like, please calm down.
She's taking the Florida bar.
Yeah,
Yeah. Well, she's worried she's gonna fail. I can maybe.
she's not gonna fail. She's just doing her little
She's the
Harvard.
type who's worried she's gonna fail, but doesn't want to seek help from someone who could maybe help her feel more confident. I get it, the Harvard type. Okay, so which essay subject do you want to do?
You can pick.
I can pick.
Mm-hmm.
All right. Um, let's do ethics.
I'm bad at ethics. That's good. It'll make me.
All right. What authorities regulate the conduct of attorneys in Florida?
The rules of or the I know the Florida Supreme Court decisions, the creed of lawyers, or the creed of the Florida Bar, the ethical duties of like professionalism, and other documents. Yeah, I don't
Yeah,
I don't know.
the oath.
The oath.
Yeah, that's fair enough. All right, Samara says, Bunny, I got you. Bunny's coming up next. So let's see if someone wants to put the entirety of it in the chat. But yeah, we'd say like the Supreme Court, the oath, the creed, the the rules of professional conduct and other documents. Okay. And if they violate these rules, they could be subject to discipline, like suspension, admonishment, or disbarment. Cool. What's the duty of confidentiality?
That you have to keep like your client's information confidential, and it applies to like anything that you gathered in the attorney-client relationship, including like seeking out potential services.
Is it different than an evidentiary rule that's similar?
Yes.
Yeah, the attorney-client privilege, right? How's it different? How's the duty of confidentiality different than the attorney-client privilege?
In the chat it says it survives death, which is maybe true.
Yeah, that is true. It's more broad. It survives the death, it survives the relationship. It's not just about admissibility into evidence, it's about, the confidentiality of the communications between the clients, or between the client and the attorney. So that's just something to note. People kind of confuse those two, attorney-client privilege and the duty of confidentiality. The attorney-client privilege is an evidentiary rule. The duty of confidentiality is an ethical rule, and the duty of confidentiality is even more broad and encompassing. Cool. Okay. So what constitutes a conflict of interest? How can it be overcome? What's an imputed conflict of interest, and how could it be overcome?
So it's like when a client's interests are adverse to like a former client or a potential former client. And it can be overcome by in the lawyer believing that they can competently represent and with informed consent by the parties in a signed writing most of the time. And an imputed conflict of interest, I think, would be maybe when someone is working like at a law firm with a lawyer that has already worked with like a former adverse client, that even though that lawyer specifically didn't work with the client, that the lawyer that works alongside with them, his conflict is imputed on the other attorney.
And how can that be overcome?
Screening
Nice.
and yeah.
Exactly. So they could be screened out. So conflict of interest is tested a lot, and that's, if there's previous or prospective litigation that could potentially disrupt their ability to reasonably and competently represent their client. But right, you can overcome it with consent, and it can be imputed to your firm, but you can also be screened out, meaning separated and not a participant in the litigation, and your firm could still handle it. So those are some really good buzzwords. You're doing incredible, amazing. All right, what
It's
about?
probably my least studied subject, so it's a good subject for me to do.
Yeah, good. I'm here. I like what Justino's done. That's a pretty cool vibe. So what's the duty of decorum?
That's to like not act crazy in a courtroom, I guess.
Yeah, fair play and justice inside the courtroom. And then what's the duty of candor?
Honesty.
Yeah, to not submit frivolous claims to the
Yeah.
court, and to be respectful and uphold the integrity of the law in your claims and transactions with
Yeah,
co-counsel.
I think I've seen like some sample answers talking about like suing people, like they can sue people just to like harass them.
Yeah, frivolous claim, and that could even lead to malicious prosecution, the tort. But yeah, definitely that would be a violation of the duty of candor. What about the duty of competency?
I to like represent someone the way that a lawyer with like reasonable similar skill, I guess, would do, not and also like not taking on clients that have adverse interests that would, make you biased or not be as great of a lawyer.
Right. And when you are not competent, can you still potentially take on the litigation potentially?
If you get other counsel and like bring them in, like if you're not or no, I don't know.
Oh, sorry.
There's so many like humans with
So I was
faces
gonna
on
say
the.
that, yeah, you could bring someone else in. Exactly. I was trying to change my background to my wall, but I kind of like being in space.
I'm distracted by like the farm animal class we have going on.
Well, that's good because you're gonna be in a room full of farm animals when you take the test, so it's good. Okay, so the
Yeah,
duty.
during the Texas bar, there was a girl that was throwing up into a garbage can less than 20 feet away from me. So that could happen to
Nice.
people.
That's awesome. That's just like amazing. It's the perfect image I want in my mind right now. What else happened? Okay,
People
so
cried.
yeah. Oh, there will be tears. People
There will
cry.
be tears around you. Yeah, just
Yeah,
don't pay attention to them.
there will be tears. There will be moans. There will be. Uh, you'll see me happy as a clam because I'm finally done my like 3 month all I do is work phase of my life. Okay. So we talk about duty of competency. You could bring someone else in if they're skilled, and you can be their apprentice or co-counsel, or if you could learn. You could learn from them, or learn from study. Okay. So what about the duty not to commingle?
That's that you have to keep client funds separate. So you have to keep them in like a client trust account and you shouldn't mix them with your personal funds or even the firm's like main account if it's like an advance or something.
Nice. Um, when can a lawyer be paid by a third party for his or her services?
when I think they have to get informed consent of the client, and they have to like swear that essentially they're not going to be biased by the third party, and that the third party isn't going to be able to like know all about all the communications, essentially that they're representing the person that they're representing and not the person that is paying them.
Right, it's the client's duty, I mean, client's decision to settle, not the paying party. Unless it's like an insurance company, they can decide to settle because it's like you wouldn't be able to take on the claim without the insurance company. When may attorney's fees be awarded in Florida and what rules apply?
I think, I mean, they can obviously be awarded as like sanctions, but I think they can also be awarded, I know in family law, if people are have a need and the other side has an ability to pay. But they could also probably be awarded for like frivolous claims or like bad faith acting in a
Right.
courtroom.
I was gonna say in contract or by statute, or you were citing Rosen v. Rosen in family law, if there's a need and the court decides. Yeah, attorney's fees, we usually follow the American rule where you don't pay the other side's attorney's fees, but you could, by statute or by contract, let's say. What are the requirements for referral fees in Florida?
The person has to actually participate in the representation of the case, and they're supposed to get like a percentage that's equal to like the amount of work they're putting into the case. And I think there has to be some kind of informed consent by the client.
Nice. Yeah, referral fees, there's gotta be informed consent by the client, and they have to participate in the representation in some regard. So you could even say that referral fees are disallowed in Florida unless there's consent and they participate and the like. What are requirements for contingency fees in Florida?
They have to be reasonable. So I think over 40% is unreasonable for sure. Normally it's more around 30%. And I think they need to be in writing and kind of be based upon like the value that they're giving to the client, I guess. Like you can't get 40% recovery if you're only working on the case for like 2 weeks.
Yeah, I agree with you. And there has to be a calculation for how the contingency fee is gonna be paid out.
Oh, and yeah, they're not allowed in domestic or criminal cases.
Yeah, and the calculation has to be in advance and after, and they're not allowed in criminal or domestic cases. Sweet. And then what are the rules regarding attorney advertising and solicitation in Florida?
You can't have deceptive advertising, so you can't say like I've won every case if you've only won one case. And you can't say anything that's like misleading, like saying you're board certified if like you're not. And if you are soliciting a client from like an accident, you have to wait 30 days. And when you do send them like a written mailing thing, you need to like make a note on it, I think in like red font, that it's like an ad, and just kind of essentially not target clients when they're in like moments of distress, unless they're, I think, a former client, then you can solicit them.
Yes, I love that. And then when can an attorney make a loan to a client?
I think it's only for indigent clients for like court filing fees.
Yeah, I mean, they can advance the fees to like support the litigation. Um, and what about taking an interest in client property?
I think it needs to be there's I know you need like informed consent for sure. It has to probably be like fair and reasonable.
Right. That's fair
And
enough.
I don't
In writing
yeah.
and informed consent, fair and reasonable. Yeah. All right, let's see. The chat room is booming.
Yeah, they've been saying a lot of things that I was forgetting.
No, it's fine. Okay. So somebody crapped their pants during my test. All right, this is a political joke. I can't make political jokes on camera because they might not let me advertise. So Justina's cracking up. So contractor statute, usually always a two-way street. If one party can ask, both can pursue. Also willing to hold J and S liable, joint and severally liable. Okay, so contractor by statute. Yeah, that's what we were saying for attorney's fees. It's got to be written, reasonable, set for a specific breakdown in engagement. Client gets 3 days to retract. You're talking about Contingency fees, sure. I mean, they're not allowed in domestic and criminal cases. So when someone took the Illinois bar, someone freaked out in their essays when their laptop stopped working. Same story with the New York bar. Someone in the middle of the essays legit yelled and said, "Fuck this," and slammed their laptop and ran off crying. It threw us all off. When I did in Georgia, some girl just shut her laptop, got up and walked out in the middle of the exam. Okay, cool. Back to the class. Can't give conclusive outcomes. Can't, okay, so this is what attorneys can't do in solicitations. They can't give conclusive outcomes. They can't boast experienced members. Right, you can solicit your family members, but not people you don't have a formal relationship with. If you have an attorney, please disregard language and letter. You can't say anything about their injury or medical condition. You're going to pay advanced costs and fees. That's what you are allowed to do to a client. Right, you can work with family and friends without solicitation issues. Alessandra's saying an indigent client you could give advances to. You're not really allowed to have a pecuniary interest in the stake of the claim. That's true. The land, property, and the claim can't be used in the bartering. Exactly. That's well done. I don't actually know who J and M is. I don't really know the initials of all of you. You can claim relationship with judge would help. Appearance of impropriety. Yeah, you can't claim a relationship with judge would help because that would have an appearance of impropriety. Janae, okay. All right, Janae, excellent. All right, cool. Linda, is there anything else you could tell me about professional responsibility?
I don't know, probably not. Other
All right.
than, I think I saw some random fact pattern about on a essay question about a lawyer having like ex parte communications with
What
a
does that mean?
judge, which
What does that mean? Ex
like
communications.
that means like when the lawyer would like talk to the judge without the presence of the other party.
Nice. Janae, what do you want to say with your hand raised?
Good morning. Well, yeah, still good morning, everyone. I was gonna say another one. I was just doing a practice essay and make sure that the attorney wasn't a part of maybe the crime or the issue at hand. Um, when they're representing someone. So basically, like there was somebody selling a piano and his attorney friend was with him, but then the person at hand, he sold a piano and it was a lie. Like it wasn't the piano that he said it was. It was misrepresentation. So part of it, and I didn't even catch it, was that make sure that the attorney was not a party or part of the maybe the crime or the problem at hand, because then they could be called to be a witness.
Right, and that's like the crime fraud exception too, where an attorney maybe can step outside its boundaries of privilege to disclose criminal intent or criminal behavior and to, exclude itself from participating in a crime. Amazing. All right, Linda, I feel like for someone who loves to go to these festivals and you're probably tons of energy, you're pretty low energy today, right? Pretty subdued.
I mean, I'm really bad at, I haven't like studied ethics too much.
I'm
And
still
so
gonna
I'm
give you
like,
a grade. You want your grade on this questionnaire?
I give myself a 40 on it.
A 40 out of 100?
Yeah.
That's what you give yourself? What's the class giver? Let's see. I was gonna give you like a 92, honestly. A 40? I thought you knew everything. All right, let's go. Yeah, 90%. We're gonna give you a 90%. B plus. All right. All right, fine. We'll take your 40 into consideration. We'll give you a B plus, an 88. An 88 to 92 is your range. That you set the bar really high. If that's a 40, I don't know who's coming next. All right, who is coming next? We're gonna have to pick up the pace a little bit, but who can rapid fire
I
with a little
I
bit?
could do contracts.
All right. You're doing an animal? All right.
Yes.
That's only fair that animal meets animal.
Yeah.
Let me choose my avatar. It's like a video game. So what are you, a bunny? What can defeat a bunny? Well, bunnies are land animals. Bunnies like carrots. So obviously, most definitely, oh yeah, gotta pick the dog.
Oh my God.
Yeah, and I got that dog in me. All right. What subject do you want to do?
Contracts.
All right, cool. Contract should be easy. Yeah, got that dog in me. So what's the definition of a contract?
A contract is a legally binding agreement between two or more parties with damages.
Nice. What types of contracts fall under the UCC versus the common law?
Under the common law, contracts for services or land, and for the UCC, contracts for goods. And also merchants fall under UCC rules.
And what's the definition of goods?
Goods are all things, all tangible and movable goods.
And what's the difference between a unilateral and a bilateral contract?
A unilateral contract, the only form of acceptance is performance. A bilateral contract has many forms of acceptance.
Nice. Let's see. Shelby's here. Shelby, are you here? You're here. She wanted to do real property first, so we're gonna do real property next, just a foreshadow. I just remembered that. Okay, so what's the difference between a unilateral and a bilateral contract? You said it right, unilateral is accepted by performance, bilateral necessitates contract formation. What's your definition of an offer?
An offer is an outward manifestation of willingness to enter into a legally binding agreement with specific terms that places the power of acceptance in the offeree.
What is an acceptance?
Acceptance is gonna also depend on whether common law or UCC governs the contract, but generally it's a manifestation of willingness to be bound by the terms of the offer. If it's under common law, it must be the mirror image of the offer terms, and if it's under UCC, it's a little bit more liberal.
I'm trying to put my dog on camera with this dog, but I don't think it allows this inception. But let me change this real quick. There we go.
Oh man, I lost immediately.
No, you're good. Okay, so what is consideration? You said a bargain for exchange of legal detriment or value in Florida.
I did not say it yet, but that is the right definition.
Well, let's go. What special rules apply to merchants?
For merchants, there's a few. They have under irrevocable contracts, they have the firm offer rule. They have, like I mentioned earlier, they have the perfect tender rules. They also have rules under issues with additional terms that will apply the battle of the forms rule and then the knockout rule and then the UCC gap filling provisions. They also have confirmatory memos.
Nice, you're killing it. I'm just focused. I'm trying to see Biscuit's teeth because he's got more teeth pulled. And I never get to see it, but now he's like yawning on camera, so I'm focused. But you're doing an amazing job. Yeah, last special rules that apply to merchants. And what about the predominant purpose test?
We apply that when a contract involves both UCC and common law issues, and you essentially are gonna figure out what is the biggest purpose or the primary purpose in the whole contract, and you will apply that type of law. But sometimes I think it's if it's an installment contract, then you can apply each law that governs each part of that contract.
And can you explain the mirror image rule, the ballot forms provision, and the perfect tender rule?
Yes, so the mirror image rule, like I mentioned, applies under common law acceptance, and the acceptance must mirror the terms of the offer. If it's anything other, that could be a counter offer or a rejection, it wouldn't satisfy the mirror image rule. The battle of the forms applies when there are different terms in the acceptance, and usually it's going to be determined on whether it's a material or non-material term, and I believe that if it's between merchants, it's going to automatically be included in the contract so long as it's not like obviously completely different than a term. And then the court will apply the knockout rule of completely different terms, and they will use the UCC gap filling provisions to essentially fill that out based on the party's intent of the contract.
It's just dawning on me how happy I am that I'm speaking to a rabbit right now about okay, but I think this is good. What is the predominant purpose test? Oh,
Um,
I'm sorry, I
yes.
already did. Okay, what's the definition of statute of frauds and what type of contracts does it apply to?
Okay, so statute of frauds is one of the defenses available to contract formation, and it applies to a certain type of contracts and requires it to be in writing and signed by the parties to be charged with essential terms, which the contracts that apply to it include contracts in contemplation of marriage, contracts that can be performed within a year, contracts for land, so like sale of land, real estate contracts, contracts for executorships, contracts for guarantorships or suretyships, contracts for the sale of goods of 500 or more. And I know Florida has some other specific ones like health insurance premiums, newspaper subscriptions, but I don't have them all memorized.
Yeah, and life insurance
And
policies.
life insurance, yeah.
Um, So,
and the exceptions to statute frauds include part performance, which essentially is if you can show that you have done two out of the three, or is it all three
in
of
Florida,
either?
it's all three. One of the essays that you read says 2 out of 3, but
It's all three.
it's all three in Florida, yeah.
Okay, so the three are either for partial payment, improvements, and possession.
Yeah, payment, possession, and improvement, yeah.
Yeah.
And then special manufactured good, written confirmatory memo, admission in court, promissory estoppel, and partial performance. And then promissory estoppel you'll associate with detrimental reliance.
Mm-hmm.
Okay, cool. What's the difference between a mutual and unilateral mistake?
A mutual mistake is when both parties are mistaken about a material term of the contract, and that usually will allow for the contract to be rescinded because there's no meeting of the minds, or if the courts consider reformation of the contract. And bilateral mistake. So yeah, bilateral mistake is only when one party's mistaken and the other one isn't, and you also have those same damages available for reformation or rescission unless one of the parties knew of the mistake and used that to essentially have the other party rely on the mistake on purpose.
Yeah, I love that. Unilateral versus mutual or bilateral mistake, well spoken. Okay, what are the remaining defenses besides statutory frauds and mistake to contract formation or execution?
So there's misrepresentation that can be intentional or negligent. There's impracticability and impossibility. There's undue influence, duress, fraud, unconscionability, promissory estoppel. There's capacity or incapacity, minority, illegality.
Yeah, fraud, duress, misrepresentation, illegality, incapacity, infancy, impracticability, impossibility, frustration of purpose, undue influence, unconscionability, either procedural or substantive, unclean hands, latches, acquiescence. Anything else we missed in the peanut gallery? Truly is like a cartoon show out here today. I like this a lot though. I might just do all cartoons in the future. Everyone just starts a cartoon character from the beginning. I never know any of your faces. I feel like I'd be a better teacher. Okay, what are the differences between material and immaterial breach?
So a material breach usually affects the entire contract and it deprives the non-breaching party from the benefit that they bargained for. And you could sue for the damages on the entire contract. An immaterial breach usually is only part of the contract is breached, but it's not enough that the non-breaching party can still retain some benefit from the contract, and they're limited to damages only based on that part, like the portion of the breach.
What's the difference between equitable and legal relief?
Legal relief is money damages, essentially money. And equitable relief is a court can provide, for example, specific performance and oh,
We'll go
precision.
through them. Let's go through them. So what are all the different types of legal and equitable relief? That's
Okay,
next.
so legal expectation damages, consequential, incidental, reliance, non-economic, I think it's like pain and wait, am I going into torts now? But pain and suffering, medical expenses,
Yeah, you're
but
going to torts.
I'm going into torts, but what else under legal?
So legal will do if it is
Nominal.
punitive or consequential. I mean punitive or compensatory, but punitive damage are very rare, so it's mostly compensatory. The main form, like you said, expectation, consequential, incidental, lost wages, lost profits, and then you were just saying nominal, reliance damages, restitution.
And then equitable, it's which I mentioned, specific performance, rescission. And I think the main difference that between the two, legal and equitable is only awarded when no legal remedy is adequate.
Right. And what about equitable relief? You said injunction, specific performance, rescission, reformation, promissory estoppel, and then quasi contract.
Yes, which is when that's basically to avoid unjust enrichment.
And what are the elements of a non-compete agreement?
A non-compete agreement, for them to be valid, they must be reasonable in scope, time, and location or geographic, whatever. And I think for duration, reasonable is considered 3 years. Anything more than that could be arguably unreasonable.
Nice. And what about what's an options contract?
An options contract is an irrevocable offer between non-merchants, and essentially it's the promise to keep the offer open for a specified amount of time in exchange for consideration.
And what's a requirements contract?
A requirements contract is usually between merchants, and it's the promise to provide you with all the goods you need.
And what's an output contract?
Same thing, just it's a promise to provide you with everything I produce.
And what's a installment contract?
Installment contract is essentially one that's paid in different, that could be separated, kind of like little mini contracts, but performance comes at specific times, and you can separate between also what law governs it depending on what the contract is for.
Nice. And what's a divisible contract?
A divisible contract, kind of the same thing, that it could be, it's like it's one whole contract that has essentially time of performance and payment for performance or whatever it is divided into different times. Performance is due at different times for both
And what's
parties.
the firm offer rule?
The firm offer rule is can only be between merchants, and it's the promise again to keep an offer open. It's not an it doesn't require new consideration. It just requires it to be in writing and signed by the merchant, and it can only be open for up to 3 months.
And uh you said liquidated damages clause?
I didn't, but liquidated damages is also a form of damages that can be determined at the inception of the contract, and essentially it just determine it's only valid if you can determine a certain amount of damages in case of a breach.
And what's an anticipatory repudiation and request for further assurances?
Anticipatory repudiation is when a party unequivocally and unambiguously gives the non-breaching party notice that they will not perform prior to the time of performance, and the non-breaching party has three options. They can sue right then and there, they can wait until time of performance comes to sue, or they can ask for further assurances, which is just asking in writing to get kind of like confirming that they will perform. And I believe the breaching party has to respond within 10 days in writing.
30, well, yeah, they have to respond to the request. So if it's a merchant, they have 30 days from the, moment of doubt to send a request for further assurances.
Oh, and the doubt has to be reasonable.
Yeah. Yeah, then they have 30 days to respond. Yeah, it's 30 days. What is the parole evidence rule and what are the exceptions?
So the parole evidence rule, it bars extrinsic oral evidence, that happened prior to or contemporaneously with the entering of a contract if the contract was fully integrated, which means that parties intended that to be the last version of the contract and everything was already within the four corners of the document. But it will be allowed if it's partially integrated, which is usually just there's no statement or evidence that that was the party's intent for it to be the last contract, and it would be allowed, but the exceptions are usually to clear up uh ambiguities, fraud, and I'm missing some, I'm sure.
So defects information, like you said, and like fraud or some defect information to clarify an ambiguous term, to show a condition to contract, to
Mhm.
show customer trade usage, or to show an additional term. What's an accord and satisfaction?
Court satisfaction is basically uh a breaching party, I guess, trying to satisfy their breach by paying a different amount, and satisfaction, that's the accord, and the satisfaction is the acceptance of the non-breaching party, whether it's like, let's say if it's a check, if they go ahead and deposit that check.
And when is a modification enforceable?
Modification is enforceable under common law if new consideration is given, and under UCC, just good faith.
What other topics do you anticipate being tested on the Florida Bar Contracts essay? And please pour your heart out here.
Everything we just talked about.
Yeah, it's pretty solid. You did amazing. All right. How do we want to grade her? See what the class is saying. 100%, 100%, 100%. A plus plus plus. All right, fuck it. 100%. A plus plus plus. You're allowed to have dinner in my household. Okay. So you got an A plus, amazing. I think maybe being the bunny rabbit was good. We can't see if you're happy, sad, or whatever, but really solid. You have a good character voice too. Maybe you should consider being a real life bunny rabbit on TV.
If this doesn't work out, that might be next.
Yeah, that could be. I wish I did. I would be like an announcer for like sports. I'd be like, and now he hands the ball off, like just talking about sports in real time. But you really have to have like that, the voice. Okay, so that was amazing. All right, we're gonna do real property. Who wants to be my volunteer for real property? All right, nice. It could be a on paper volunteer. Let's see. All right, Wes, you can. All right, Wes, you're up.
What's up, Andrew?
What's going on, man? All right.
Yeah, I'm out of the house right now, so unfortunately I can't be a rabbit, but
It's all
you
right,
can.
man. You could. We can imagine. What do we want? What do we want to imagine you as? What animal do we imagine you as?
Been chasing iguanas away all week, so you can picture me as an iguana.
You said an iguana?
Yeah, they're
Alright.
all over my deck right now.
I want everyone to imagine that I'm speaking to an iguana right now as we do real property. Imagination. Okay, real property. Iguana. Rosie, stop being a nuisance. Okay, what are the different types of easements and what are their elements?
So there's two big types. There's easements and gross and easements appurtenant. Easements and gross are generally given to an individual like a mineral company or a logging company to come on and take profit from the place, but not always. It can be given to another person just to like use the property. Easement appurtenant is given and is conveyed with the land. Under easement appurtenance, there's easements, express easements, which are typically in writing, made with the intent to convey that easement along with the property. There are easements by necessity, which is when a landlocked piece of land isn't accessible from a public highway or other public frontage. That doesn't have to be in writing. There are easements, totally blanking on the name, but like an adverse possession easement, which is easement by prescription. That's open, notorious, continuous use, hostile use for a period of 20 years in Florida. And then there are easements by implication, which to me, I kind of just, when you see it, like it's kind of like an easement by prescription, but not necessarily. Like maybe it was used during that time and conveyed and the other person kept using it. They built out the easement. Mostly easements can be terminated. Well, all the easements can be terminated by merger. But if it's reconveyed to someone, like an easement by necessity is always there. It's automatic if you can't access your land. What else?
Terminate an easement.
Sorry?
How else can you terminate an easement?
You can well, if it's expressed, if the easement ends, if it's easement by prescription, the person exits the easement and expresses an intent not to do it. I see in the comments, like if it's no longer necessary, if there's public frontage built, if you withdraw permission on an express easement, things like that.
Cool. Yeah, express easements, implied easements, easement of pertinence run with the land, easement and gross are gonna be personal in nature. Affirmative easements versus negative easements. Florida doesn't really recognize negative easements for light or air, but we do recognize riparian rights. You said easement by prescription and easement by necessity. Really solid work. What are deed formalities in Florida?
So for a deed to be valid in Florida, it needs to be validly conveyed and delivered. That's what we call, or for a deed to be validly conveyed, it has to be properly executed and delivered. Execution in Florida involves signing it in front of two attesting witnesses, much like a will in Florida. Delivery usually takes place via physical giving to someone else, but not always. The important part of delivery is that the person actually expresses an intent to convey the land to another party and places the deed beyond their control. You can't give it to a third party and be like, in 20 years, give this to so-and-so unless I ask for it back, because you're not placing it beyond your control.
Right. And what does adverse possession mean?
Adverse possession means somebody acquires the land through open, notorious, hostile, continuous use over a period of 7 years in Florida.
And what's necessary in Florida with or without color of title?
With or without color of title. I want to say, remind me what color of title is. Intent?
Appearance of title, like maybe you have a defective title.
That one
So
I don't know.
in Florida, if you have a defective title, color of title, then you just have to have made an enclosure on the property, like fenced it or something. If you do not have color of title, no appearance of title, then you have to actually have paid taxes on the property.
Okay.
Um,
This one, remember.
yeah, I mean, not that important. I think it's pretty cool how like the sun is flickering in the Northern Lights. Has anyone else here ever seen the Northern Lights? Anyone in the class? Little side thing.
I have.
Where'd you see it? I've seen them too. Where'd you see them?
I saw them in like a northern part of Sweden. It wasn't like a that thick of a northern lights like Norway moment or wherever the cool ones are, but I was already in Stockholm, so
I saw them. My brother lives in Alaska. I saw them twice in Fairbanks, Alaska, and then we drove off to these like I don't even know what they were. These like hot springs in whatever, and we saw them on the way there, and then I saw them again on the way to the airport at like 5 a.m. in the morning, and both times they were sick. Like they looked like literally exactly what it looks like in my background, but just like purple too. It was incredible. And my brother, my parents have both been to Alaska like numerous times to visit my brother and have never seen them. And I've only been there one time, and like it was his wedding, and my brother and my parents came early and then left right after the wedding, and I came the day of the wedding and then stayed later, and like it just happened that I got to see them, and like it's just good timing. But yeah, Northern Lights I've seen. They're cool. They're cool. That's cool that you saw them too, Linda. All right. All right, sorry to disturb you, Wes. So we know what color of title means, color of the Northern Lights, appearance of title. That's what color of title means. But Wes, here we go. This is the biggest question of the day. Tell me everything you know about mortgages like I was in 10th grade and you were trying to sound as smart as possible, including what is a foreclosure action?
So mortgages are it's a security interest held in land from a lender to a lendee. The mortgagor takes an amount of money from the lender and secures it to the property. There are, for mortgages in Florida, I know this more goes with tenancy, but like with married couples and tenancy by their entirety, you need the consent of both people to mortgage the land. If it's a tenancy in common, it's only mortgage on that individual's interest. Pretty sure anyways. Mortgages also can validly contain clauses like due on sale clause, acceleration clause in Florida, maybe require you to maintain insurance on the property, or they can deem that the terms of mortgage have been breached or that you're delinquent. Under Florida, there's a statutory right of redemption. So if a foreclosure action is brought an individual has a right to tender the delinquent amount within that amount of time, basically up until the foreclosure sale is complete and it's sold to a third party. I can't remember if you can waive it in Florida. I don't believe you can. I do believe that you can convey a deed in lieu of foreclosure, which is sometimes something I've had issues with, so I've tried to know the rule. But like if you just want to avoid all the foreclosure proceedings, you can basically deed the property to the bank or the lender. I know I'm missing some stuff, but trying to think what else I can think about mortgages.
So
When mortgages in Florida also, because Florida is a lien theory state, not a title theory state, a mortgage is only a lien on the property. The lender has equitable title, but not legal interest in the property until if a successful foreclosure action is brought, they don't acquire it till then. In Florida, mortgages are one of the few things that can pierce the homestead exemption.
hold up, I'm making sure. Statutory versus equitable right of redemption. Which one is before and which one's after?
What do you mean?
Like,
Equitable right of redemption cannot be waived, and that's from notice of foreclosure action until final sale.
right, and then the statutory is after the foreclosure sale.
Yeah, statutory is like any additional time period that the legislature puts down.
Nice, my bad. All right, continue. Let's hear more about mortgages. I could kind of sum up like, what is a mortgage? A mortgage is a loan secured by property, and in the event of a default, the lender can initiate a foreclosure action. The mortgagor is the borrower, the mortgagee is the lender. The senior mortgagee is the lender who has the top priority to
purchase money as well. Purchase money mortgages in Florida always have priority. That's a
Yeah.
mortgage used to the money is given. The money that is given by the lender is the money used to purchase the property.
Excellent. That's a purchase money mortgage, which would have priority. So in the event of a default, you have a foreclosure sale. He was saying the equitable right of redemption is the homeowner's right to buy back the property before the sale. The statutory right would be after. When it comes to a mortgage, you could take a mortgage subject to or expressly assume a mortgage. Expressly assuming a mortgage means you're taking primary liability. Subject to means you're taking a mortgage with secondary liability. There's some provisions in mortgage that are valid and enforceable, like no early prepayment clause, an acceleration clause, or a due on sale clause. And he was saying there's such things as deeds in lieu of foreclosure, which means instead of having a foreclosure sale, you just transfer the deed. That's what there's also instruments like an equitable mortgage, which means like a mortgage that's not recorded, but it still operates as a mortgage. In the event that the foreclosure sale cannot pay off the senior mortgagee, or there's junior mortgagees who need to get paid off, they will need to seek a deficiency judgment from the lender. Pretty solid? All right.
Yeah, I think I forgot the assume and subject to, and I believe that's like various types of penalties. I know where I believe in Florida, if it's like expressed in the lending agreement that can you convey that always? Like, is there always right to convey that mortgage to someone via assumption or subject to?
Not always, if it's, banned that, the mortgage is not to be transferred, a mortgage.
So that
is
is strict, that is strictly construed by the terms of the contract.
Yeah, I mean, the mortgage, think of a mortgage as a loan, like a promissory note. It's a foreshadow to commercial paper, and a collateral agreement, foreshadow to secured transactions, right? You collateralize the loan to the property, and the loan has interest, and if you don't pay it back, then they could foreclose on it. It's very similar to, secured transactions, default, and the like. So really solid work. What type of notice jurisdiction is Florida?
Florida's a pure notice jurisdiction.
So what does that mean?
Pure notice is, well, there's notice, race notice, and race. notice protects a property interest from any people claiming any subsequent purchasers. Basically, a bona fide purchaser for value is protected from subsequent purchasers claiming the property if they have recorded the mortgage. So long as that subsequent bona fide purchaser, which is a purchaser for value without notice, doesn't have notice, they have the preeminent interest in the property.
And what are the different types of notice?
In terms of, well, I see 6, like actual and constructive. You're talking about like
Yeah.
race notice.
Well,
Actual constructive, I believe in Florida, filing a notice or filing a record with your county office is operates as actual notice. But actual notice generally is when a purchaser or someone who's about to purchase a property like actually knows that somebody owns it. Maybe they conducted inquiry notice and went to the property and looked at it. They see that somebody has built a home there. They spoke with someone, the neighbor, that's like, oh yeah, so and so's owned that property for 20 years. Constructive notice is more like you have information via a public record or posting, but it's not like you might not have gone to the property and observed people on the property or actually viewed the recorded notice or the
Right.
recorded deed.
Right. So actual notice means you have literal notice. Inquiry notice means a reasonable inspection of the property to put you on notice. And constructive notice or record notice means that it was recorded in the county records. Is Florida title or lien theory state?
Titles, Florida is a lien theory state, meaning that the lender has only equitable title to the property, not legal.
And what happens if there's two parties and they have a JTROS and one party takes out a loan on the property? Will that sever the JTROS?
I know that it can't be
The answer
done.
is no, in a lien theory state, if one party takes out a loan, it won't sever the JTROS because it gives them a lien, not title. Meaning, if that party who took out the loan dies, then the lender cannot collect from the other party or the property because it was a lien, not a title transaction.
Right.
So what are the duties of a landlord and what are the duties of a tenant?
Landlord in Florida has to deliver actual possession. There's has to ensure the premises are safe for human, not consumption, but human living. Duty to make major repairs. So, in terms of like a warranty of habitability, has to make sure the AC works in the winter or in the summer. I guess winter down here too. Heat works in the winter. There's no dangerous conditions. Has to make major repairs. AC goes out. They have to fix it. Stove stops working. They have to fix it. Tenant has a duty to pay rent and not commit waste. There's 3 types of waste. There's permissive, ameliorative, and affirmative. Affirmative waste is where the tenant is actually destroying stuff. Permissive is where they allow a condition, maybe like a leaky faucet or a leaky toilet, to allow to continue, and the damages of property. They know about the condition. They don't do anything to fix it or inform the landlord. And ameliorative is where the tenant actually improves the property value, but still violates the terms of the lease.
Nice.
So landlord has a duty to provide for quiet enjoyment, make sure that there's no other, like the person can fully enjoy the use of their property.
All right, nice. Hey, for time constraints, I think I'm gonna have to take over the questionnaire duties, but I wanted to demonstrate to the class how well my students were doing, and you did a great job, Wes. It's kind of taking longer than I would love. Okay, so let's see. What are different types of waste? We said ameliorative and affirmative and permissive. What are the 3 types of joint tenancies? So there's tenancy in common, joint tenancy with right of survivorship, and tenancy by the entirety. What are the different types of deeds and what are their warranties? So there's a general warranty deed, there's a special warranty deed, and there's a quitclaim deed. The general warranty deed has the 6 covenants, the present covenants of sizing, the right against encumbrances, and the right to convey. It has the future warranties of general warranties, further assurances, and quiet enjoyment. What is a real covenant versus an equitable servitude, and what's required for a covenant to run with the land? So a real covenant is remedied by money, and equitable servitude is remedied by injunction. For it to run with the land, there has to be notice, there has to be intent, it has to touch and concern the land, and for covenants, it needs to be in writing, and there should be privity, horizontal and vertical privity, depending on the benefit of the burden. These requirements have been relaxed. Okay, what are riparian rights and what are rights related to water in Florida? So riparian rights are water rights, and in Florida, we have the reasonable use theory that if you were using the water for a certain reason, then you're allowed to continue that use. So it's also the you could consider the flow of the water. You can't restrict your neighbor's flow of the water. What are the different types of leases and how much time is necessary for notice? So the different types of leases are tenancy for years, a periodic tenancy, a tenancy at will, and a tenancy at sufferance. And if someone could put in the chat, just so I don't confuse it, the notice requirements for week to week, month to month, year to year, etc. Because I know it is a little different for residential and commercial, and I don't necessarily know at the top of my head, but y'all should. What's the doctrine of equitable conversion, and what does that mean? So equitable conversion means that the risk of loss will shift to the buyer during the period of escrow after the contract has been signed and before the closing date. It also means that after the contract has been signed, that the parties will be bound by the terms of the contract, even if they die, meaning their estate will have to continue with the contract. Do all contracts for the sale of land need to be in writing, and what about leases? So, yes, all for the sale of land, and no, not for leases unless they're over 1 year. What are adjacent rights and lateral rights, and do you have a right to a view? So adjacent, subadjacent, or sublateral rights, these mean your right to maintain your premises in its natural form, and it means that you won't be intruded upon below or beneath the surface. Do you have a right to a view? Not in Florida under the Eden Rock versus Fontainebleau case. And then what's the rule against perpetuity? So in a rule against perpetuities, no interest in land is valid unless it must vest, if at all, within 21 years of the death of a life and being at the time the interest was created, or it actually vests within 1,000 years in Florida. All right, I didn't mean to cut you off, Wes, but it was going to take me 3 hours, and I actually have like 7 students I have to tutor today. So we got to get to it. All right, I'm going to give myself a 94. I'm going to give Wes a 96, and I'm going to see what's going on in this chat. Samaris is smiling. It's giving Wolf. You and Ramel, abandonment, no longer necessary. Estoppel, appearance of title. You need to pay taxes if you don't have color of title. I'm glad I explained that. I don't know what I explained or we explained. You've seen it Noel in Iceland. Nice. So we've seen Iceland, I think you said Sweden maybe, or Norway and Alaska. Alessandra, a dream. I mean, my brother lives there. We can go visit him anytime if you want to be friends. You saw him in Iceland in February. Nice. Iceland sounds nice. Absolutely amazing. Is my brother in the Air Force? No, he's a firefighter. They actually have a lot of fires in Alaska, like wildfires. And they also have a lot of people who commit suicide. He was on Alaska Road Truckers. I don't know, some show where they showed him saving someone's life. I know, I just teach people for a living. I'm the least bit hero in my family. There's no statutory right of redemption in Florida, is what we're saying. And I think that's been confirmed by Angie in the direct message. Although Florida has a statutory right of redemption, the statute does not allow redemption after the foreclosure sale process has been completed. In order to redeem the property, the owner must pay the amount owed in judgment to the mortgagee by the date specified in the judgment or any time before the clerk of court finalizes the sale with the issuance of the certificate of sale. Thank you for that, Angie and Linda. So Linda also double checked. There's no statutory right. Only judicial foreclosures have a equal right. Would you mention a statutory right? I would mention it and then say it's not recognized in Florida. That's how you get lots of points. You guys are all asking the same question. All right, Res, You went from a 94 to a 91 based on echo of our statutory right of redemption claim. Okay, you got a lot of feedback on that. That's the thing, man. If you're gonna teach in front of the class, you're not allowed to say a single thing wrong or you will get destroyed. That's why I say just if you know it in the chat, like Erica did. So year to year, tenants must give at least 60 days notice before the end of the annual period. Quarter to quarter, tenants must give at least 30 days notice before the end of the quarterly period. Month to month, tenants must give at least 30 days notice before the next rent is due. And week to week, tenants must give at least 7 days notice before the end of the weekly period. Samaras reaffirmed that. Year to year is 60 residential, 90 commercial. Month to month is 30 residential, 60 commercial, and week to week you have 7 days in advance. Wes, I know you're the man, Wes. Don't worry. Wes, first time test taker. My results with first time test takers are phenomenal, and I expect you to continue that trend. You did an amazing job. All right, in the nature of time, I think I'm gonna have to take over the microphone. You guys are all amazing. You're just not as fast as me, which tends to be why no one can cover me in the sports I play. But let's go through some of these other ones. Let's just do it in alphabetical order. All right. Fasten on your seatbelts, ladies and gentlemen. So what's the definition of a negotiable instrument and what article number of the UCC governs commercial paper? All right, Rob, you're up. Are you here, Rob? Now I'm going to pick on people at random. Actually, let's do Ramel. Ramel, are you here? Mr. Cow himself?
Yeah, I'm here.
All right. What article number of UCC governs commercial paper?
Oh gosh, 3.
Perfect. That's all I want to know. You passed, you got an A plus. All right. You got an A plus on commercial paper. So it's Article 3 of the UCC, and a definition of a negotiable instrument is a medium of exchange for money that does not include cash or securities. What words signify commercial paper on exam? None of them, because it's not exam subject anymore. It would be check, promissory note, cashier's check, IOU, order, bearer paper, something of the like. What are 2 types of commercial paper and who are the parties? We have notes and drafts. Notes are 2-party instruments, drafts are 3-party instruments. Notes are going to have a maker and a payee. Drafts are going to have a drawer, and then the bank, which will be the drawee / payor, and then the person who's paid, which is the payee. What about the necessary elements of negotiability? Shelby, are you here? I'm not gonna put her on the spot, but we were going over this last night. I've been working hard. Just like you guys have all been studying, I've been working hard. I actually work harder than you guys study, and I do this all year long. So that's why I don't have sympathy for you. I just know what you're going through. But let's talk about commercial paper. A signed, written, unconditional promise to pay a fixed sum of money with or without interest on demand or definitive time to order or bear with no additional undertakings. A signed, written, unconditional promise to pay a fixed sum of money with or without interest on demand or definitive time to order or bear with no additional undertakings. What's the difference between order and bearer? How are each transferred? Order paper, order. Oh, there's an iguana, Wes. It's so funny you said that. That's what they're barking at. This iguana in the tree. That thing looks like a dragon. All right. Signed, written, unconditional promise to pay a fixed sum of money with or without interest on demand or definitive time. Order and bear with no additional undertakings. And how are each transferred? Bearer paper by possession. Order paper is going to be by negotiation, by endorsement. They're gonna have to actually sign it like to someone. What is a holder in due course? A holder in due course is someone who takes the instrument for value in good faith without notice. So a holder in due course is subject to the real defenses, but not the personal defenses. The real defenses would be fraud in the factum, whereas a personal defense would be fraud in the inducement. Real defenses are like fades, fraud in the factum, alteration, illegality, duress, discharge in court, suretyship, or statute of limitations. The personal defenses, you're thinking of contract offenses like lack of consideration or unfair bargaining terms. So remember, holder in due course is like a bona fide purchaser. They pay for the instrument and they're without notice. Shelter rule means anyone downstream the holder in due course, any holder downstream will take shelter in the holder in due course's status. Presentment warranties. Presentment is when you go to get paid. Transfer is when, you sign a check over to someone else. Presentment warranties are that they're authorized to, pay it out and there's no fraud or alteration. And transfer warranties are they're authorized to transfer it and there's no fraud or alteration. You don't really need to know too much else about commercial paper, like special endorsement would be specially to someone versus qualified endorsement, which would be like a non-recourse endorsement. Commercial paper is pretty easy. Just think of checks. Just think of what happens if you present a check, you're supposed to get paid out. And if you don't, it's kind of messed up, right? Condition. It can't have a condition. It needs to be signed, written, unconditional promise to pay a fixed sum of money. So if I say, I'll give you $300, Tommy, on January 4th, if the Dolphins win the Super Bowl, sign Tommy. Well, that condition could never occur. Does anyone know why? Because the Super Bowl is after January 4th. No, Dolphins could win it this year, but it couldn't occur. But let's just say it was on March 4th. It's still conditional. If I say on the condition that they win the Super Bowl, then it doesn't constitute commercial paper. All right, let's see. Rob has no voice. That's fair enough. And no one wanted to do commercial paper. No, Ramel the cow, and that's not an insult. You are literally a cow. You did good. You did good. All right, let's see what's next. Con law. All right, let's see. Is anyone there who wants to be con? Erica, are you alive and willing? I'm not gonna ask you tough questions. Don't worry.
I mean, I'm alive. Am I willing is the question.
All right. So, what's the sunshine law?
So the sunshine law is that, hold on. The sunshine law is that you have to, anytime that there are two or more politicians that are having a meeting, that needs to be an open meeting or at least have minutes of the open meeting that can be essentially examined by the public. So it's an access to, technically, isn't it like an access to courts? I do verbal diarrhea when I get put on the spot like this. I'm sorry, but
Ew, gross.
is that right, wrong?
No,
not-
no. Verbal diarrhea, gross. So sunshine law, yeah, right of access and all records and proceedings need to be in the public. And the exception is if it's an unplanned meeting between two legislators, not including the governor. And one more question, what's the homestead exemption?
The homestead exemption is that you can't have, no one can actually pierce the main property, like your home itself. It is half an acre in a municipality, 160 contiguous, can't pronounce that word, acres
Contiguous.
in a non-municipality. And it essentially protects the home from any creditors, but a homestead can be pierced by several different kind of means and certain exemptions to it. I think lawyers can pierce through it. Obviously, the mortgage companies can reach through it, but it protects the home and everybody that is living in the home from creditors.
Nice. So just so everyone's on their toes, I'm gonna call on some people to answer some questions randomly, so pay attention. If not, I'll just skip you. Hey, Lauren, are you here? The Lauren Miller?
Hi, yeah, I'm here.
What's up? How are you?
Hi, I'm okay. How are you?
Boot camp went well?
Boot camp was great. Yes, boot camp was great. Thank you.
No one had full, complete live participation attendance, but you almost did. You were really good at showing up. Almost. But now I'm gonna do boot camp virtual in the future. It's gonna save me a lot of money in printing costs, but
We're gonna miss you and the flowers, Avi.
I know the flowers are a good
The
touch. You know.
flowers.
My
I
mom
almost have a whole bouquet.
almost a whole bouquet. My mom raised me so well. All right, let's talk about some questions that I have for you. What's required to enact a law in Florida?
A single subject. It has to have an enacting clause, like be enacted. It has to be read into the read like 3 times. And what else? It can't be it has to be related to the welfare of the people, and it can't be vague or overbroad.
That was really good. I could see your
Thank you.
confidence rising. Yeah. All right, I'm gonna ask you one more question because
Okay.
that was really good. We've come a long
Thank you.
way. What what's subject to strict scrutiny in Florida?
Race, but
Yeah.
is race now? Yeah, race, alienage, gender, and
Gender, not quite. Race,
no,
age,
gender's intermediate, I think, and religion, physical disability.
Yeah, anything in the First Amendment and disability, race, alienage, national origin, disability, anything in the First, Fifth, 14th Amendment, right to vote, right to travel, right to work or be in a union, right to have a jury trial, access to courts, right to privacy, contraception, marriage, procreation, education, right to raise your family. These are all things that would be subject to strict scrutiny analysis in Florida, right to have guns, right? Things like that. All right, you did amazing. I'm proud of you. All right, let's talk
Yeah.
about the first 16 amendments. So First Amendment is there's 5 things on the First Amendment: freedom of speech, freedom of religion, freedom of the press, freedom of assembly, and freedom of petition. The Second Amendment is your right to bear arms. The Third Amendment is your right not to have to shelter a soldier during the war. Your Fourth Amendment is going to be the right against unreasonable searches and seizures. That's going to implicate probable cause, warrant requirements, and uh, things like that. The Fifth Amendment is 5 things on the Fifth Amendment: due process, the takings clause, the Miranda rights, your right to counsel before adversarial proceedings have begun, your right against self-incrimination, and the double jeopardy clause. The Sixth Amendment is your right to a speedy trial, your right to counsel after adversarial proceedings have begun, and the confrontation clause. The Seventh Amendment is your right to trial and jury cases. I mean, your right to a jury in legal cases in federal law, but we also have a similar amendment in Florida. The Eighth Amendment is your right against cruel and unusual punishment. The Ninth Amendment hasn't been incorporated to the states. The 10th Amendment is preemption and state sovereignty, anti-commandeering clause, state police power. The 11th Amendment is sovereign immunity. So you can't sue the state, but Florida has waived sovereign immunity for tort claims and for operational but not planning decisions. You can also sue a agent of the state in their official capacity. The 12th Amendment has not been really incorporated to the states. The 13th Amendment is bans racial discrimination even in private places, and then the 14th Amendment, equal protection. It's talking about suspect classes and when they're discriminating against a certain group of people, and then it also has privileges or immunities when it's specifically related to interstate travel. 15th Amendment is the right to vote, coupled with the 19th, and then 16th Amendment grants Congress taxing and spending powers. Ramel, raise your hand. What's up? What's up, Mike?
Yeah, we didn't cover this very much, but you just touched on it really briefly. But you can sue the state of Florida for what is it? Operational stuff, but not for planning.
Yeah.
Activities. Okay, thanks.
Nice. I just said that. That's amazing. That's a repetitive. Operational, not planning. That's good. That's right from a Florida essay itself. Like if the state's just saying, oh, the parade can't go down this route, then they can't be sued for some injuries. But if the state plans the actual parade, then they could be sued for injuries, right? Operation versus privacy. All right, bet. So what's subject to strict scrutiny? You gotta put some stuff in the chat, but we talked about it. Lauren crushed it. First Amendment rights, any constitutional rights really, and then things that are targeting race, alienage, national origin, disability, right to vote, right to travel, right to work, right to be in a union, right to have a trial by jury, right to access courts, right to privacy, fundamental rights in Florida. What's strict scrutiny definition? So the law needs to be necessary to achieve a compelling government interest and be narrowly tailored to that means, to those means. Intermediate means that it's necessary to achieve an important government interest and it's substantially related to that. And the burden of proof will be on the government. And then rational basis just means it's rationally or reasonably related to legitimate government purpose, and the burden of proof will be on the plaintiff. What's the difference between content-based and content-neutral restrictions on speech? Well, content-based is subject to strict scrutiny, and it's, when it's targeting actual speech. Content-neutral is when it's just a time, place, and manner restriction, and then it would be subject to intermediate scrutiny that leaves that's narrowly tailored and leaves alternate means of communication. So substantially related to an important government interest and narrowly tailored and leaves alternative means of communication. What type of speech is not protected in the First Amendment? So words that are likely to incite imminent loss activity, hate speech, defamation, obscenity, and false or misleading commercial speech. What are the requirements of enacting an ordinance or law in Florida? Lauren nailed it. It needs to have an enactment clause. It needs to relate to the health, welfare, morals of the people. It needs to have a single subject. It can't be vague or overbroad. It needs to conform with the elements of bicameralism. So read into each house 3 times and then presented to the governor for signature. What's the difference between chartered and unchartered counties in Florida? Well, chartered counties can enact their own laws that do not conflict with the state of Florida, whereas unchartered counties have to follow the general laws. Chartered counties, municipalities, and cities within chartered counties have what's known as the home rule power, which is their power to govern themselves. What's the difference between general, special, and general law of local application? General law applies to the whole state. Special law applies to an area or county, and it is subject to a referendum or vote. And the general law of local application is based on population. Vagueness, it means it's not clear what's being punished, and overbreadth means it's punishing more than it's intended to. Sunshine law, there's a right of access to all governmental proceedings, and it must be in the public, and the exception is for unplanned meetings between 2 legislators, not including the governor. And the argument against sunshine law would be, oh, the legislators saying they have a right to privacy. However, that argument will fail because the sunshine law is an enumerated right. Homestead exemption, so it'll protect half an acre inside a municipality or 160 acres outside a municipality from judgment creditors, excluding the government, judgment taxes, and then liens, mortgages on the property. So, or like lawyer fees for the procurement of the homestead or defense of the homestead. So condo fees, homeowners fees, taxes, construction liens, mechanics liens, these things will also be exempt from homestead. There's also homestead as a tax deduction, but I read recently that they're not testing that anymore in Florida, that you can deduct $50,000 from your county appraised value of your house, but they said they're not testing that anymore. So just focus on the judgment creditor exemption. Procedural due process, we're going to require notice and hearing, the Matthews v. Eldridge test. Kluger doctrine means that if there is an overriding public necessity, then they can, we would consider that a reason for overcoming strict scrutiny, such as access to courts. If there's an overriding public necessity, then courts can restrict access to courts under the Kluger doctrine. A special legislative session is called to discuss one particular issue, and they're only allowed to talk about the issue they met for unless they get 2/3 vote by both houses. And I believe they last for 20 days. Is that right? Special legislative sessions? If someone can.
Yes.
Yeah, 20 days. Okay, cool. What's the difference between substitute process and equal protection? So substitute process is when a law is discriminating against everyone, whereas equal protection is when a law is targeting a specific group of people. Privilege and immunities clause is when we're discriminating against out-of-staters, like charging out-of-state commercial fishermen more for commercial fishing licenses than in-state fishermen. The Commerce Clause, Congress can regulate the channels, instrumentalities, and economic activities of interstate commerce. Wait, hey. It's just an iguana. Don't let this iguana cause beef between you dogs. So what's the Dormant Commerce Clause? Well, under the negative implications of the Commerce Clause, states cannot enact legislation that would unduly burden interstate commerce or directly burden interstate commerce on its face. What's a possessory versus regulatory taking? So possessory taking is when the government physically takes your property, and a regulatory taking is when legislation by the government renders your property economically useless or unviable. And that would subject the Penn Central multi-factor balancing test, which are the factors that the court will consider to determine whether a takings has occurred, whether you've been deprived of your investment-backed expectations, and whether your property has been left economically unviable. It would be a per se takings if they, put a construction pole in your property, or it would be a per se takings if they made it so that you can't do anything with the property commercially. A non-conforming use versus a variance versus amortization. So non-conforming use means you're grandfathered in to doing something that you had previously zoned for after zoning laws have changed. A variance means you're applying to do something different than the zoning laws, and amortization means you're slowly going to conform to the new zoning laws slowly over time. Speech and debate clause, we're going to protect legislators for their acts while on the government floor in the acts of legislation. This one's really important. Separation of powers. Please look out for this on a common law essay. Separation of powers. Use the words usurpation, entanglement, entwinement, or encroachment to say that one branch of the government has stepped on the toes of the other branch of the government. The commandeering clause, so that's when the federal government forces a state to enact legislation. They can induce them, but they can't coerce them. They can have conditional funding. We're not going to give, Congress won't give the states construction, funding for the roads if they don't change the drinking age, but they can't say states must change the drinking age. Full faith and credit clause means we're going to recognize the judgments of other states. In Florida, ex post facto law, we're not going to punish people retroactively for behavior that was legal at the time it was the behavior occurred. Impairment of contracts clause would be a law that punishes a law that interferes with an existing public or private contract. Look out for like a curfew. Like if they say, no students are allowed out past 9 p.m. or no people are allowed out past 9 p.m., that might, impair contracts with clubs and late night businesses. What's a bill of attainder? Punishment without a trial. So they just punish people without giving them an opportunity to be heard. Who are the constitutional officers? So in Florida, constitutional officers would be like the mayor, the governor, the sheriff, the appraiser, the CFO, the clerk, right? These are people who pretty much work for the state. They're considered constitutional officers and they have vested rights, and they can't really act outside of those vested rights. All right, let's see what's going on in this chat. Did we talk about go bonds, revenue bonds, and I don't think we did. It's supposed to be neither real property or con law, but let's just add it right here.
It's not on the coverage list anymore, by the way.
Oh,
So
the types of bonds?
they took it off.
All right, bet. Let's not even talk about that. Okay. So all good. That's how you learn year to year. Me too. Thanks. Great advice. When you see sunshine law like issues, make sure to mention sunshine law plus 3 of the fundamental rights of the Florida Constitution that apply: access to courts, right to jury trial, and access to public records. They get strict scrutiny, and doing that analysis can get you a lot of points. Good work. Substantive due process, strict scrutiny analysis, I mean for clarification. Same thing goes for right to privacy. When you see that, a lot of times you also see unreasonable search and seizure, but both also get strict scrutiny under substantive due process, and so does excessive punishments. Race, language, national origin, privacy, disability. If you look at the Florida con law coverage list, the first 18 points are like the basic rights. And looking at that list when doing essays, especially for the con law, has been a game changer in me getting all the weird things there in the model answer, because I just don't think the issue spot all those without them. Erica just put in her binder. Linda put that in the chat. Where do you find the outlines for the rest of the subjects? They're on the board's website. Linda's sending it out now. What is the suffrage and elections? It's about voting, right? Your right to vote, suffrage. Okay. So yeah, I like what Janae said. Always talk about standing, and state action and justiciability, whether it's ripe and not moot. So honestly, we should just add that what is standing and what is justiciability and what is state action. Improving, I feel like these used to be in my questionnaires, but somehow they got swept by the sands of Father Time. All right, so standing, it needs to be injury, cause and factor, and redressability. Justiciability, it's got to be ripe and not moot. And state action means it has to be state action to implicate the Constitution. So that probably leads us right into the Crim Pro questionnaire. we can pretty much fly through this one. Don't tell, I prepared y'all for this. Don't say I didn't prepare you. I didn't even used to teach this subject because they didn't used to test it that much. Now they test it all the time. So Fourth Amendment is, you know, no unreasonable searches and seizures. Fifth Amendment, I already talked about, due process, takings, double jeopardy, Miranda rights, and right against self-incrimination. And then Sixth Amendment is confrontation clause, right to counsel after adversarial proceedings have begun, and your right to a speedy trial. The right to privacy in Florida is heightened. It's expressly stated that you have a strict right to privacy. Miranda rights are, you have the right to be silent, you have the right to an attorney. If you cannot afford one, one will be provided for you. And they have to be given when you're in custody, and a custody occurs when a reasonable person would not feel free to leave. And a custodial interrogation is when they're asking you questions. Now, if they just pull you over at a routine traffic stop and say, hey, you know, where are you going? That's not interrogation. But, you know, once they arrest you and start asking you questions, they do have to give you these Miranda rights, which after you've invoked your Miranda rights voluntarily, then they can't resume questions and they have to ask you Miranda rights again after a reasonable time, which has usually been interpreted to be about 14 days. What's the privilege against self-incrimination? Under the Fifth Amendment, you have the, I plead the Fifth. Dave Chappelle can teach you all that. What's the exclusionary rule? So, evidence that's seized in violation of the Fourth Amendment will be suppressed. And under the fruit of the poisonous tree doctrine, any evidence that's subsequently found as a result of that excluded evidence will also be suppressed. The stop and frisk rule, if they believe that, if a police officer believes that criminal activity is afoot, they can pat you down for weapons. And if they feel something that seems to give rise to probable cause or seems like it would be illegal, then they could continue the search. That is also known as a Terry stop. So stop and frisk and a Terry stop are essentially the same. What's required for a warrant? Probable cause, right? You need probable cause, and it has to be issued by a neutral magistrate and describe in particularity what's to be seized or who's to be arrested. When is a warrant not required? This is a big one. We use this space as mnemonic. Search incident to arrest, plain view doctrine, automobile exception, consent, exigent circumstances or hot pursuit, and stop and frisk. Another one that I could think of is the inevitable discovery doctrine. Like they were going to find this shit out anyway. Tommy was about to snitch on the whole gang. What's an impermissibly suggestive lineup? Like, let's see, it was a leprechaun who was 2 feet tall who did the crime. And then we bring a bunch of 6'5" finance bros up to the search and one leprechaun. Well, that would be unduly suggestive, right? Because clearly you picked a leprechaun. I feel like, I hope that word hasn't been canceled in 2024. I didn't mean anything by that. All right. What is the plain view doctrine? It just means that, like, if you know, cop and you see something in plain view, then you're allowed to continue the search. You're allowed to seize that evidence. What's the search incident to arrest doctrine? So once you arrest someone, you're allowed to search their wingspan and cavity for, well, not like their complete cavity, let's say, but you're allowed to search their wingspan for, you know, additional criminal evidence. Robbery, so larceny plus force. Conspiracy, the bilateral requirement, right, where you have to have an overt act towards the crime. Burglary is gonna be pretty much just trespass with the intent to commit a crime therein. Florida has 3 types of murder: first, second, third degree murder. Third degree is premeditated or violent felony. Second degree is depraved heart or intent to inflict great bodily harm. And then third degree is during the commission of a non-enumerated felony. And then pretrial procedures, you know, they have to have their first appearance, their arraignment. There has to be probable cause, or they're entitled to a non-adversarial probable cause determination hearing, or if it's a felony and they're still being held, then adversarial probable cause determination hearing. You know, you're entitled to a lawyer. Different things that's more crim pro. All right, let's see what my chat of destiny says. So if a bill of attainder in the facts, it would be a good idea to talk about procedural due process violation. Alessandra says her literally your mind is blown. And Rob, you're 100% Irish, you're not offended. Nice. Everyone thinks I'm Irish because of my beard, but y'all can keep thinking. All right, and Linda said suffrage and elections. Regulation of elections, secret ballot. General elections shall be determined by plurality of votes, not majority, 44 to 45% wins. Minor party candidates may not be treated differently than major party candidates. Electors, Florida Constitution, what they call voters. You're disqualified if felony conviction. Okay, so this is that truth in Florida. You're disqualified from voting if you have a felony conviction or adjudicated incompetent. You can't vote or hold office until your civil rights have been restored or the disability removed. And you can't have your votes restored in Florida if you're a felon or convicted of sexual crime. So voting rights and right to run in office, never possible for those felonies. So watch out for that if you tend to run for office. Voting rights come back after sentence except for murder and rape. And you have 8-year term limits for governor. Governor, Florida legislators, and U.S. representative senators. But if it falls in the middle of term, you can do more. So if a governor takes over 2 years into the governor's term and serves 2 of the 4 years and then wants to run again, his name is allowed on the ticket as long as by the time he's running, he has not already served 8 years, despite the fact that by the end of his term, he'd be running for 10, okay? And then primary, general, special elections. Linda, you're just giving me the whole statute here. General elections.
I was just sending him my notes on it. You don't have to read
All
it.
right, I'm a reader, man. I'm a voracious reader. If you send me something, I'm probably gonna read it. So, general.
February 2020 Florida common law essay has this issue on it if anyone wants to see it in an
All
essay
right,
fact pattern.
So general elections, first Tuesday after first Monday in November may be suspended or delayed if the state of emergency. Special elections and referenda shall be held as provided by law. And if all candidates for an office have the same party affiliation and the winner has no opposition, any party can vote. Those are Linda's notes. Ramel said thanks. Yes, you do need 2 people for Florida, and okay, you don't need to overact. You need something more than mere preparation. So we would call it substantial step. Okay, so that's the Florida Prim Pro. We did this whole first row and we did this one. All right, we're almost done. The other ones are pretty easy. We did real property too. So let's do torts. Torts is fun. So, all right, who wants to play this game? Grace, are you with us?
Yes, I'm here.
All right, what are all the intentional torts?
We have assault, battery, intentional infliction of emotional distress, false imprisonment, no, I was gonna say duress, but that's not a thing. Conversion, trespass to land, trespass to chattel. Intentional interference with business transactions also.
Yeah, I like that. Assault, battery, false imprisonment, trespass to land, trespass to shadows, conversion, intentional interference with the business relationship, intentional infliction of emotional distress, malicious prosecution, intentional endangerment, some privacy torts, and maybe defamation of a public figure. Awesome. What are the transfer intent doctrines? So under transfer intent, it's like it could be tort to tort or person to person. If you intend to punch Johnny, Johnny slips it and you hit Tommy, you could still have the requisite battery or assault. And then same, if you intend to only scare Johnny and you throw the punch, but you think you have, that ability to stop it, but you don't, and you actually hit him, you intended assault, but it would transfer to battery. It's not going to transfer from like intending to shoot a deer and shooting a person, but it would transfer from intending to shoot a person and shooting another person. Negligence, duty, breach, causation, damages. And then causation has to be actual, which is the but-for cause, and then proximate, which could either be the zone of danger, the foreseeable plaintiff. Defenses to negligence, statute of limitations, which has been reduced to from 4 to 2 years for bringing claims. Defenses to negligence, like what do people think out there for defenses to negligence?
Modified comparative fault.
Oh yeah,
assumption
that's
of
the best.
risk.
Yeah. Assumption of risk or comparative fault. Yeah, those are the best examples. I was wondering what I was getting at there. So Florida's a modified comparative fault state, and then Florida will also recognize assumption of risk, not as a complete defense, but as a valid defense. So contribution or assumption. Contribution, assumption, statute of limitations, those are some good defenses to negligence. Superseding or intervening causes. So superseding cause will completely cut off liability, whereas intervening causes will shift liability, but not completely. So superseding would give rise to indemnity, intervening would give rise to contribution. What is negligence per se? It's when a statute defines a duty of care. So it would have to be designed injury in the protected class, like a speeding limit. What's res ipsa loquitur? The thing speaks for itself. So the pot off the balcony or the scalpel in the person's body. It was under the exclusive control, and in the absence of negligence, injury would not occur. What are the elements of premise liability claim? So it's duty, breach, causation, damages. Does Florida recognize a difference between licensees and invitees? Florida does actually have a licensed invitee, which is like a hybrid, but the I don't know if this word got canceled, Rob, but the totem pole of hierarchy would be invitee, licensee, known trespasser, unknown trespasser. You have the highest duty to the invitee and the lowest duty to the known trespasser. What duty is owed to known trespassers? No real duties except not to have unreasonably dangerous conditions on your property, like a doorbell that shocks people when they touch it. So what's the eggshell plaintiff rule? You take them as you see them. I call it the glass jaw rule. If you punch someone and you shatter their whole face, you're gonna have to pay for their entire facial reconstruction, even if it's not their, you didn't know that they were such a glass jaw. Florida is a modified comparative fault jurisdiction. If you're over 50% at fault, then you cannot recover. Florida has abolished joint and several liability for negligence cases. The limit on punitive damage in Florida is 500,000 or 3 times compensatory, the greater the two, unless it's like abuse to the elderly or the mentally disabled or something really messed up. What are the elements of defamation and what's the difference between public and private? So I think this is a Sullivan case. Defamation is going to be dissemination of, or the publication or dissemination of material that injures another's reputation. A public plaintiff, they need to prove actual malice. A private plaintiff, they just have to show negligence. A newspaper has 10 days to retract a defamatory statement once they've been given notice, and then they can only be sued for actual damages. That's called the media defendant rule. Slander per se in Florida is recognized for crimes of moral turpitude, loathsome diseases, chastity, and about a business. And these are negligence or slander per se, where damages are presumed. Invasion of privacy would be intrusion upon seclusion, appropriation or misappropriation, and public disclosure of private facts. Florida does not recognize a separate tort for false light. We would wrap that up with defamation. Strict scrutiny will apply to products liability, wild animals, or inherently dangerous activities or instrumentalities. Florida has abolished the 1 bite rule, so you can be held strictly liable for dog bites. You heard that, Rosie? What are the elements of products liability case in Florida? So in Florida and other states, a product liability case occurs when a commercial supplier, retailer, producer, manufacturer, or distributor place a defective product in the stream of commerce. So there can be the strict liability theories of design defect, which is the risk utility test or the consumer expectation test. There's the manufacturing defect, meaning they didn't create it as it was designed. There's the express warranties, failure to warn, and inadequate warning. And then the implied warranties of merchantability and fitness for a particular purpose. Merchantability means that it doesn't work, and fitness for a particular purpose means it doesn't work as it was specifically warranted to. Always remember, I said this 1,000 times. They say, I've heard this saying before, it takes 7 years to become a master of something. I've been teaching the bar now for 7 years. So I've become such a master of this that I've said this probably 7,000 times. And I'll say it one more time because people still forget it. Whenever there is a strict liability argument for a products liability case, there's a contemporaneous argument for negligence. So do all those things I just talked about, you know, design defect, manufacturing defect, express warranty, implied warranty, merchantability, fitness for particular purpose. Then do, alternatively, Tommy will argue it was negligent to design it this way. They had a duty to design it this way. They breached that duty. They caused damages, and period. That's a negligence argument. So get your points by arguing strict liability, and then alternatively, negligence. Always argue for negligence on torts essays. Throw the kitchen sink at them, as I like to say. What's vicarious liability? So that's third-party liability, being liable for the acts of another. It arises in a master-servant relationship, employer-employee, agent, principal, things like that. There can be apparent authority, implied authority, express authority, different types of authority. Responding superior usually applies to the employer-employee relationship. Frolic, I think of a frolic like a video game, like frolicking off in the woods, like playing Zelda or something. And then a detour, just like a quick detour on the way to work. Frolic is outside the scope of business, detours within the scope of business, so the employer can still be held liable. Different types of negligence include negligent entrustment, negligent supervision, negligent design, negligent manufacture, negligent hiring, negligent training, negligent time management by me, by allowing students to slowly do the questionnaires at the beginning of class. No, I'm just kidding. Just like negligence in general. You guys all got A's because it's important to do things slowly and methodically, but I got to do this a little bit faster for my own day. So, what's the attractive nuisance doctrine? Well, the attractive nuisance doctrine means that, like, if you lure a child onto your property, they'll be treated as an invitee, not a trespasser, and you'll have a lot of duties owed to them. So the broken trampoline is what we think of. What's the difference between a survivorship claim and a wrongful death claim? Survivorship claim are claims that your state can bring after you die on your behalf, and a wrongful death claim is a claim for the actual wrongful death. It applies a lot to doctors and malpractice. You know, Michael Jackson's doctor allegedly was responsible for his wrongful death, allegedly. What are the elements of malpractice in Florida? So in Florida, it's, you know, when a doctor deviates from the standard of care, and you do need to provide notice, you need to get the claim authorized by a third-party expert and give the doctor the option of arbitration or mediation, and they have 90 days notice, and they have a limit on actual and non-economic damages. So Linda, fun fact queen, Florida has abolished joint several liability, but not for indivisible injuries per gross Lyons, and indivisible injuries is its own bullet on the tort coverage list. Right, so I mean, if it's an indivisible injury, I guess then it could be like a product defect case where someone got injured by a product that two people, you know, were indivisibly responsible for creating, then they would be subject to joint and several liability. But please don't let Linda scare you off with her fun facts. Please. Okay, so can you please go over parent-child immunity? So Florida doesn't recognize parent-child immunity. A child can sue their parent. In fact, someone close to me did that because their dishwasher fell on their foot, and then they sued their parent and collected under the homeowner's policy. So you can sue your parent in Florida. You're not directly liable for the acts of your kids. You're probably liable for negligent supervision unless they're like a little baby or a toddler and they like poop on someone or something. I don't know. I don't have babies. I don't know what they actually do. All right, let's continue on for the sake of time. So we did all these subjects that were super fun. Wow, we're almost done. Amazing. Let's talk about secure transactions, which are this one. Of course, one more question. Can you claim vicarious liability for parent-child? Like I said, not really, unless there's some, you know, if it's a severely mentally disabled child, if you're their guardian, you know, that could give rise to it. But typically the child will be held to its own negligence standard of a child of similar intelligence and like-mindedness. All right, Angie, here we go. They don't purposely poop on people, but it does escape the diaper sometimes. Yeah, Angie, I think you could be liable. Like if I'm on an airplane and you're sitting there with your baby and the poop protrudes from his diaper onto my seat, I think that is one of the rare instances where you could be held vicariously liable for the negligence of your baby. All right, let's keep it moving. All right, Angie, are you here? You're here to talk about poop, or are you here to talk about the real shit? What article of the UCC governs secure transactions? Angie, number 9. All right, good, you passed, A+. All right, what are 4 different types of tangible collateral? So we have consumer goods, we have inventory, we have farm products, and we have equipment. What is consignment? So consignment is like a pawn shop where you give someone something with the expectation they're going to sell it, and then they give you a portion of the proceeds. What are intangibles, and what's the difference between tangible, intangible, and intangible intangibles? Well, intangibles are things you can't touch. Tangible intangibles would be like a check, Article 3, like an actual check. Intangible would be like an accounts receivable or a patent, something you really, really can't touch. What's the process of attachment? So attachment is how the lender gets rights in the collateral, and we do it via security agreement. What's the difference between commingling and accession? Commingling is when something has become so affixed with something else that it's been totally commingled. Like, let me shout out Michael B. Jordan and Dr. Schmood right here. I don't know if you can see this, but I don't know where my screen is. Let me see me. Oh, you guys can't see this. All right, here. This is called the CMOS drink. I'm a huge proponent of CMOS since day one. I used to read Dr. Sebi when he was alive. So this is CMOS, but it also includes ginger and mango. The ginger and the mango and the CMOS have all commingled to form this actually tasty drink. And if you ever drank CMOS before, it's absolutely disgusting. It tastes like the middle of the sea, but they've managed to mix it properly. They've commingled all the elements. Now, what is a session? A session would be like, all right, here we go. This plant, you can't really see it, but this is a, well, shit. This is a plant with aloe, right? I guess sunburn, I need this. So the aloe is assessed with the pot and, you know, the soil, but the pot and the aloe are together, but we could still see them. I could pull the aloe plant out and that would be an accession, like a tire on a truck. You can see the tire on the truck. This is commingling the mango and the ginger. All right. You can tell I got some issues. Okay, so what is necessary for a security agreement? It needs to define the collateral and the parties. We're not going to allow ultra generic language in a security agreement. We'll be more lenient in the financing statement. What's a pledge? A pledge is someone who has rights and collateral via possession or control, and it's oral. There's no written agreement, but they still have rights. What's the process of perfection? So you perfect via financing statement. Now remember, some things you can attach and perfect via control or possession, but most things you attach via security agreement, you perfect via financing statement, which is actually filed with the secretary or the county or whoever it may be, and that puts people on notice that you have an interest. So what's a PMSI, a purchase money security interest? And a PMSI in consumer goods, you have automatic perfection upon attachment. A PMSI in non-consumer goods, you have a 20-day grace period for perfection. So if you attach a non-consumer PMSI and then someone else comes and perfects 15 days later, you can perfect 3 days after that, because it would be day 18, and still have priority. So you have the grace period for non-consumer goods. If it's a car, then you would have priority, super priority. Who has priority amongst perfected and unperfected creditors? Perfected. Perfected versus unperfected. Perfected will always win. PMSI will defeat them all. They have super priority on the totem pole, if you will. What happens if there's a default? Can a secured party breach the peace? If there's a default, you can collect, you know, hey, let me get my, like, I don't even want to tell you. I have a situation right now where I have collateral for a loan I gave to a friend, but I told my friend I wouldn't call him out on camera. But if he doesn't pay me, I'll definitely call him out. So yeah, like, let's say I lend someone money, they use that money to buy a car, the car's a collateral, they're not paying me back. Am I allowed to go get that car back? Absolutely. But I can't do it without breaching the peace. So if I do it and it's, you know, I have to bring my guns out, that's not okay. I'd have to get the security guard, and you would actually need what's called a writ of replevin. I showed that Simpsons clip sometime about the writ of replevin. It's moderately funny. Okay, so what else do you know about secure transactions? Erica, what else do you know about secure transactions? I think this is your moment, if you're here.
I mean, there's a lot of things that we can know. You can get sued for essentially conversion. Well, I won't even go into things that don't matter on the exam. So ultimately on the exam, we basically got everything covered on that end. But on the secure transaction side, the key takeaway that I've seen on the multiple choice was always that the questions are going to go on who has priority and who's a subordinate lien holder and how they will essentially divvy it up. That's ultimately one of the main questions that I've seen.
Nice. All right. Let's talk about family law. Let's see, Erica, you're still here. What type of divorce state is Florida?
No fault.
All right, Justina, you're up now. Let's see. What are the different types of alimony in Florida? You don't want to be an animal or anything?
Yeah, no, it'd be temporary, it'd be lump sum, periodic, and rehabilitative.
All right. I'll get this dog back in me. Yeah, so we don't recognize permanent anymore in Florida because unless you've been grandfathered in. And how is marital property divided in Florida?
Equitable,
Equitable distribution state.
equitable distribution.
Yeah, I think this is pretty simple, right? Florida's a no-fault divorce state. For a court to have SMJ and PJ, you know, traditional personal jurisdiction factors, SMJ, it's about 6 months of residing there. Alimony is going to be, you know, how much they've contributed to the marriage, what they need, what their lifestyle is like, what they sacrifice, just list out everything. And then we're going to use equitable distribution, where there's going to be a presumption that we're going to split up marital property equitably, and then non-marital property will be retained by the original party. A time sharing agreement, again, best interest of the child, and then just list a bunch of factors, you know, what's good for the kids. There is a constitutional right to raise your kids in Florida, so we definitely want to presume equal sharing and then go from there. There could be what's known as there's sole custody, where that's like the worst case scenario, you just have sole custody. Then there's split sharing, where it's 50-50, and then there's what's known as ultimate. Sorry, this CMOS is making me dumber, all this drinking. Ultimate, which is like where one party does sports and the dad does math, and then the mom does church, and then the dad does gardening, you know, like different hobbies or whatever. It's ultimate. It's not split by time, it's split by activity. Okay. What's necessary for modification to a substantial change in circumstances? It no longer needs to be unforeseen in Florida. What's necessary to relocate a child after divorce? So you need to petition the court if it's over 50 miles. They have changed the law now that if you move the kid back within 50 miles, or you move back within 50 miles of the kid, that automatically raises a presumption of a substantial change in circumstances. But typically, you know, just think that once the final settlement agreement has been written, any changes would require petition to that court. So what are the elements of a prenup agreement in Florida? As you know, it's got to be signed and in writing. Postnup agreements, I believe, should be signed and in writing too. I guess it would be by jurisdiction, but you know, you better get that signed and in writing if you do have a postnup. Prenup is before marriage, postnup is after marriage. Make sure that it's, you know, there's no situation where the one spouse isn't uninformed and they were tricked into signing it or something like that. Paternity in Florida, you know who the mother is, especially if you have video footage. The father, it would be a 95% DNA test. If you're over 95%, then you are the father. I feel like I could make way more jokes now that I'm a cartoon character. I feel like I got the South Park. Yeah, I'd be like, fuck you, idiot. No, I'm just kidding. So what's the legal, that was my Cartman. That was bad. All right, what's the legal effect of adoption in Florida? So a legal adoption, it's the same as parenting rights. It will sever inheritance rights from the original parents if it's a sincere adoption. Now, if it's a stepfather adoption, or if you're adopting the kid after the parent has died, then it's not going to sever the biological rights. But adoption will treat adopted children as actual children in Florida. Can anyone else tell me some other issues about family law issues in Florida?
Hey, it's Janae. So you can't waive child support ever, even in like a prenup or a postnup. And then I don't want to go on a tangent, but I thought for the father, don't they have the registry, and that also counts as a way of saying that you're the parent? Like
Yeah, definitely. You're in the registry, or if you accept in writing that you're the father, or you're 95%, then I like that. You can never waive child support, even in prenup. And remember, no contingency fee with domestic disputes. Um, did you want to say something, John? You're good.
Child support, if the father apparently has like 20% of time sharing, they get an reduced amount of child support. Child support is set by Florida guidelines. Guidelines can be deviated by up to 5% by the judge. If it's more than 5% by the judge for deviation money, then apparently written findings need to accompany that adjudication.
Amazing. Yeah, they have the statutory guidelines, and like you said, they deviate over 5%, then they have to have some special findings in order to do that. So family law essays should be easy. You should love a family law essay, but don't get, stuck and write too short of an essay. Write 3 strong essays, and that'll lead to passing. All right, we have one more essay subject, and I'll talk a little bit about Florida multiple choice, but I just want to see how the internet's going to do me. So why did the man living in Alaska name his dog Frost? Because frost bites. What do you call a dog that has been left outside in the cold for an extended period of time? A chili dog. What kind of dog likes taking a bath every day? A shampoodle. And we'll do 2 more. What breed of dog goes after anything that is red? A bulldog. I don't get it. What breed of dog goes after anything that is red? Oh, a bulldog. 'Cause
It's the running of the bulls on
Yeah,
my
yeah.
screen.
It took me 2 reads. I got it on the second. I thought it was like my dad used to drink that bulldog beer, and I used to collect the bottle caps, not realizing my dad just had a drinking problem and I just had a bunch of trash. Why are dogs terrible dancers? Because they have 2 left feet. That is good. All right, we need 2 more. These are actually kind of good. Which dog breed loves living in the Big Apple? A New Yorkie. What was the little Scottish dog's reaction when he first saw the Loch Ness monster? He was terrified. What do dogs get after they graduate from obedience school? Their masters. Whenever I take my dog to the park, the ducks always try to bite him. I guess it makes sense since she's purebred. That's my favorite one. When you cross an aggressive dog with a computer, what do you get? A lot of bites. All right, that's the one I could use at my meeting because it's so not funny that it's funny. All right, good job, everyone. We did jokes. So the only one left I have is actually trust, which is not an essay subject anymore. And then we just need to talk a little about Crim Pro, Civ Pro, evidence, and business endies. And I'll just show you some brief materials, and then I gotta get moving. So what are the necessary elements of private trust? Sit tap, there needs to be a settler, with sound capacity and over the age of 18. Intent, trust race, a trustee, ascertainable beneficiaries, and a valid purpose. What are all the different types of trust and what are definitions? We use the Tricidunks mnemonic. The fuck does it stand for? Tricidunks for testamentary trust, revocable trust, irrevocable trust, spendthrift trust, inter vivos trust, discretionary trust, mandatory trust, oral trust, no contest trust, which are not allowable in Florida, charitable trust, secret trust, which are in a will and mention beneficiaries and are enforceable, and semi-secret trust, which are in a will and do not mention beneficiaries and are not enforceable, and a totem trust, which is a payable on death account. What are trusts presumed revocable or irrevocable in Florida? Revocable. What are the duties of a trustee? I think we had like PLUPS, which was the duty to act personally, the duty of loyalty, the duty to prudently invest, and the duty to separate and earmark funds. How may a court remove a trustee? So when may a court, if there's a petition by the settler, the trustee, well, not the trustee, the settler, the beneficiaries, or the court on its own initiative. Remember, the hallmark of trust revocation and modification and creation is settler intent. What are spendthrift provisions and who can pierce them? So spendthrift provisions make it so that creditors cannot access the corpus of the trust until after distribution. It can be pierced by alimony, child support, government taxes, and judgments. That is true. what is the Cypress doctrine? It means that if they have a trust that is going to a charity and then that charity no longer exists, we'll substitute it for another charity with a similar purpose. What's necessary for modification of a trust? Like we said, petition to the court, revocation, petition to the court, or the court can decide on its own, and it has to serve the settler's intent. When does a trust need to be in writing? If it's testamentary, like in a will, or it involves real property. And what else is important to know about trusts? Anything anyone else got for me about trusts? Couple more dog jokes. I recently planted a pet tree and it's like having a pet dog, except the bark is much quieter. You heard that, Biscuit? How are dog catchers in the UK paid? By the pound? And this one's got to be the best one. Number 13, my favorite number, and about football. Biscuit, this is the joke of the lifetime. Why didn't the dog want to play football? It was a boxer. That is my favorite joke ever. All right, let's do a little bit about the Florida multiple choice essay subjects. And I'm gonna go with the pros, my former students who are now big shot attorneys, getting that big money, living the
There's
good
a
life.
question in the chat.
Oh no, my worst nightmare. All right, Angie's laughing. Angie says no. Angie says 9. Janae, assume 50-50 time sharing, cannot waive child support. That's right. Lauren saying that's funny. Erica, you cannot take contingency in child support marriage either. Justino, you should have def used the avatar for the joke. Janae, gotta love dog dad jokes. So far, total and trust. If the trust is changed later, but the original is still earmarked for the original beneficiary, which wins out? I've had a couple questions on this. For total and trust, which is a payable on death account, if the trust is changed later, but the account is still earmarked for the original beneficiary, which wins out? So if it's a if it's like a life insurance policy, the policy will dictate who the beneficiary is. If it's a totem trust, which means, I mean, it's kind of a confusing statement here. You're saying that there's a trust and then there's a bank account that's payable on death. I would believe that the terms of the payable on death account like that would prevail over a conflicting trust. But I know you've had a couple questions on this and they seem really difficult. So maybe you can explain in the chat how you've addressed those questions. But I think we're getting a little in the weeds there, but go ahead and weed it out. In the meantime, let's talk a little bit about business entities, evidence and the two procedures. So business entities, I have Joelle's outline. Partnerships versus corporations. I'm not going to ask Shelby this question, even though I know she knows it. Partnerships are subject to unlimited liability and flow through taxation. Corporations are subject to limited liability and double taxation. Now, you can elect limited liability as a partnership, like an LLP, an LP, and LLC, or you can elect flow through taxation as a corporation, like an S corp, right? Really good outline that I encourage everyone to go through. Joelle's outline. Remember, most questions about partnerships on the test, the truth is going to be that both partners are held liable. If Tommy's a silent partner, but the third party thinks that Tommy is a partner because he's on the letterhead, Tommy will be held liable. And there could be these theories of apparent authority, actual authority, right? For partnerships, there's the process of dissociation, which is like stepping away from the partnership. And then that could end in a, termination and liquidation. So general partners have all general partners. They're responsible for the managerial decisions. Limited partnerships have a general partner responsible for management decisions and a limited partner who has limited liability and is just liable for investments. LLPs have all limited partners. LLCs, again, have all limited partners and they elect flow through taxation and limited liability. And then C corps have shareholders and the common stockholders have voting rights. They can vote for the board of directors. They can vote for fundamental changes like stock splits, mergers, acquisitions. They have derivative rights, anti-dilution rights, direct suit rights, things like that. Preferred shareholders have dividend priority. Hey, Rosie, why are you eating that? They have dividend priority. So that's some thoughts about corporations and partnerships. Like I said, dissociation, dissolution. That's how partnerships go. It'll be dissociation is like when you dissociate, and dissolution is when the partnership dissolves, whereas corporations are the ones that liquidate and terminate. Corporations, they have to file articles of incorporation. If they're going to issue shares, they have to comply with SEC regulations. They have to, send out a prospectus. Blue sky laws are gonna refer to intrastate issuances. So when it's just within one state, that's gonna implicate the blue sky laws, if you see that question. Cumulative voting rights and cumulative cumulative preferred stock. Cumulative voting rights allow all the common shareholders to stack their votes for one chair, and they benefit the smaller investor. Cumulative dividend rights allow preferred shareholders to get payments in arrears before common shareholders can get paid for dividend priority. So yeah, articles of incorporation have to have all these things: the corporation name, the name and address of each incorporator, registered agent, number of shares authorized, and things like that. Ultra vires acts are acts outside the scope of the business. Wow, Rosie just chewed down this tree. I don't know whether to be proud or mad. Good job, Rosie. Tree chewer. Florida corporations have broad powers. They have to file taxes. There could be different types of stocks. Remember, common stock is the main stock type of stock that gives you voting rights. Preferred stock gives you dividend priority. Promoters are people who try to promote the stock, like a club promoter. They promote the sale of the stock, and they can be liable for contracts pre-incorporation and post-incorporation unless there's a true novation. Like I said, Joel's outlines are super fire. This is like a 33-page outline that I'm not going to go over in its entirety, but I wanted to get the main points about corporations and partnerships. And here's a kind of a good slide: general partnerships versus limited partnerships. General partnerships, all partners are general partners. Limited partners, there's a general partner and then one or more limited partners. I can't really see that full chart in its entirety, but really good outline. Don't be nervous about business entities. Just focus on, do I know the differences between the different types of entities, between partnerships and corporations? And do I just have some idea of what things will trigger voting rights, which would be like voting for the board of directors, stock splits, mergers, consolidations, any fundamental change to the company. And then partnerships, really be on the lookout for acts that could bind the other partner via a parent authority or implied authority or something like that. One question they love to ask is, on the model questions they ask, Tommy or some business, ABC company, is selling all of its assets. Does that need a vote? Yes, because selling all of its assets is essentially a liquidation event. So, hopefully that'll help you. Most people do horribly on business entities. So if you just have a general concept, and I'm telling you, if you just read over this outline by Joel from head to toe one time, it'll put you in a much better position than any other student. The other topics I want to talk about are procedure and evidence. So I'll look at Joel's evidence form, and then I'll look at Barbara's for the other two. Evidence is tough, especially if you're taking Florida and federal. The tough part is the distinctions. Like Florida does not allow reputation testimony. I'm sorry, Florida only allows reputation. It does not allow opinion testimony when it comes to character evidence. Florida doesn't recognize the learned treatise doctrine. Florida doesn't allow for the testimonial spousal immunity privilege. So there's a lot of little nuances in Florida that you really want to learn. And in the classwork, if you go to, any of our courses, including self-guided or the complete course, but in the complete course, if you go to classwork and you go to evidence, we have evidence outlines, and one of them has this right here. Florida and federal evidence has all the distinctions, right? This is a really good thing to review at the last minute to understand the distinctions between Florida and federal. Like Florida recognizes a journalist, lawyer, client, psychotherapist, sexual assault counselor victim, domestic violence advocate victim, human trafficking victim advocate, husband, wife, clergy, accountant, and trade secrets. So these are some, a great chart of distinctions with Florida evidence. And then we have these really colorful sheets that one of my students, Hannah, made. And, they tell you about really important things in Florida that you need to know. I would definitely recommend people going over these charts and going over Florida evidence, you know, a few more times, because Florida evidence is tough and you can confuse it with federal evidence. So Florida exceptions are admission by party opponent, admission by silence conduct, authorized admissions, vicarious admissions, co-conspirator admissions, and then prior statements, prior and consistent statement, prior consistent statement, and prior statements of identification. This is a really good, you know, sheet that Hannah made. Learned treatises are only admissible to attack expert credibility once it's been established as authoritative. Ancient documents over 20 years old. Be very wary to let in a police report in Florida. It's most likely going to be hearsay. Right, so this is, you know, really great stuff for Florida evidence, and again, Joelle's Florida evidence outline is as good as it gets. Remember, it's got to be relevant, and it's have any tendency to prove a controverted fact. It'll be relevant, and it has to survive the balancing test, where it's not more prejudicial than probative. So again, Joelle has all these Florida evidence distinctions, right?
Where's his outline?
It's in all the folder, it's in all the classes. So if you're in the complete course, for instance, and you just scroll down to the bottom of all the classwork, one thing that I have is student made materials. So I have Daniela's outlines, Barbara's outlines, Jacob's, Will's, Hannah's, Amy's, Joelle's, Florida Bar mnemonics. This is a really
Got
good
it.
out- people who love, you know, Sad Fret Me, Greachy. Like these, you know, if you love mnemonics, this is our mnemonic sheet that's also down there too. So, you know, different strokes for different folks, but I tend, and I'll take a few. If any of you guys want to become future helpers and really help future students, and you have amazing outlines, send them to me. I love collecting these and honestly teaching from them because they're proven to work. So lastly, I'll go over Barbara's outlines for just touch on them: civil procedure and criminal procedure. Barbara crushed Florida Civ Pro, so I'd highly recommend going over this outline. You know, PJ, it's going to be the minimum contacts or domicile, or they've been served within the state. Subject matter, this is really good. So circuit court has subject matter over probate, estate, guardianship, and competency. Cases involving juveniles except traffic. Title or boundaries to real property, so that one comes up a lot. Ejectment, except landlord evicting tenants, but if it's a other way around. Equity suits exceeding, I think this has actually been moved to $50,000, and actions at law exceeding $50,000. And just one administration, I think it's moved up. So then the county courts are actions at law that are under 50, equity cases that are under 50, homeowner association disputes, and landlord evictions under 50,000. So yeah, a lot about personal jurisdiction. So venue is if it's a local action, then it's the county where the land lies, right? If it's a transitory action, so it's where the defendant resides or where the cause of action accrued, or any county in Florida. If it's a non-resident, then it's where that resident or where that person was served is going to be where venue's proper. She says a lot about the weeds here in venue. So Florida corporation resides in any county in which it has or keeps an office for the transaction of its customary business. And for domicile, corporation is domiciled in any state where it has incorporation or a nerve center, principal place of business. So transfer of venue, change of venue, you can change to a venue that was originally proper. Forum non-convenes would be the dismissal and the refiling in another venue. For service, you need the delivery and the summons. So summons and a copy of the complaint. It must, it can be made by a non-party adult appointed by the court or a sheriff or their appointee. You could have personal service or substituted service. So if it's a defendant's usual place of abode, left with someone at least 15 years of age, federal or suitable age, and that's the key thing, that it's so like you can leave it with the butler if they're there and they're over the age of 15. You can have very narrow exclusions for nail and mail and things like that nature. I'm not going to get into the super weeds here, but I would encourage all of you to go through Barbara's statute about or outline about service and all these different things. So pleadings, remember that fraud must be pleaded with particularity. Otherwise, it just needs to have the ground for SMJ, a short and plain statement showing the ultimate facts that they're entitled to relief, a demand for judgment, and a demand for damages. So that's what's required for a complaint. And right, if it's fraud, it needs to be pleaded with particularity. 20 days for the defendant to respond. So the 12B motions, SMJ, PJ, improper venue, insufficiency of process, insufficient service of process, failure to state a cause of action, or failure to join an indispensable party, same as in federal. SMJ, failure to state a cause of action, and failure to join an indispensable party can be brought at any time. These need to be brought in their first opportunity or they're waived. One thing that gets people is if it's not brought in an answer, but then it's brought in an amended answer, that's okay. You're allowed to bring in an amended answer. Now, if you file a pre-answer motion and don't bring it, then try to bring in an answer. You cannot do that. It's been waived. Remember, counterclaims versus cross claims. Cross claims are co-parties. Counterclaims are against the other party. Discovery tools. 30 state interrogatories for Florida. Federal is 25. Really, really solid stuff, this outline. I mean, I'm not going to go into every single point, but I would encourage people to go over Joelle and Barbara and Jacob's outlines, especially, and Daniela, Will's, Amy's, and the others. So impleader, intervention, and interpleader. Impleader is bringing someone into a case. Intervention is a third party jumping into a case. And then interpleader is forcing two defendants to litigate amongst themselves, two stakeholders. Class action claims, remember the cant mnemonic, commonality, adequacy, numerosity, and typicality. So 2 voluntary dismissals, an involuntary dismissal, summary judgment, adjudication on the merits. These will all lead to claim preclusion. 1 voluntary dismissal, you can, as long as it's without prejudice, you can refile again. Yeah, it's no wonder that Barbara got a 28 or 29 out of 30 because this is an amazing outline. And if you just read this thoroughly, if you're concerned about Florida Civ Pro, this is a top outline to read. So jury trials, pretty good stuff. Civil, you're gonna get 6. Then she means eminent domain cases, you'll get 12. So you get 3 peremptory challenges, unlimited for cause. You can't use race or gender because that's, state action. So remember, for the directed verdict, if there's after the opposing party has presented their evidence, summary judgment is after discovery, directed verdict is after the opposing party is presented. And if you move for it, then you preserve the belated directed verdict for later. Right? Belated directed verdict. New trial within 15 days, belated JMOL within 15 days. This is all Florida stuff. Relief from judgment, you have up to 1 year for all these things for, mistake and all that. There's no maximum time for SMJ or honestly clerical errors. There's no maximum time for either. But yeah, see, clerical errors can be brought anytime at all. The rest have to be brought within 1 year. I'm looking over this outline and I'm like, no wonder Barbara did so well. This outline is phenomenal. This is the top outline in the state. So things that are subject to interlocutory review, meaning they can be appealed without a final judgment, granting a new trial, injunctions, PJ or venue, immediate possession of property, or distinct and separable claims. That'd be like the collateral order doctrine. And then I love this terminology and other shit. A leaser is a civilian appointed to serve process. Ad damnum is a demand for damages. Rule nisi is an order to show cause why the court should not order something. And scire facias is a judgment to revive an expired judgment. And then she gives us some limitations. So it's usually the 10, 20, 30 rule in federal court. The general rule, anything in which you had 14 in federal court, you have 10 in state court. 21 days in federal, you should have 20 in state, and 28 days in federal, you should have 30 in state court. So incredible outline from a top performing student on civil procedure. And we have to do criminal procedure. It also reminds me that we have to do wills. But for wills, one of the great things is we had Marion, who got a perfect score in wills. She actually created this PowerPoint that I highly recommend people to go over. I mean, without getting into too much detail in these last couple subjects, Florida is a strict per stirpe state. So we have per stirpe distribution, right? We see that in this PowerPoint. Florida recognizes the elective share. So the wife can take 30% of the estate if she's left out of the will. If there's children from previous marriage, they get 50% and the wife gets 50%. We have pretermitted children and pretermitted spouses who are children and spouses who weren't written in the will, but then came into being after, and they're going to take as if they were in the will. Florida treats half-blood relatives differently than whole bloods. Half-bloods, basically, this is how you calculate. Give each whole blood sibling a 2 and each half blood sibling a 1, and then that's how much their proportional stake would be. I'll do that exact same way. Wills, so will formalities must be in writing. The testator must sign the will. They can't have any dispositive, disposition of property after the will. It needs to be signed in the presence of 2 witnesses, right? Florida does not recognize holographic wills. Florida does not recognize partial revocation of a will. No partial revocation. A codicil's amendment to a will, it needs to comply with will formalities as well. Remember that if there's a will that's revoked and then the new will is created and the new will is revoked, that revocation, the second will not automatically revive the first will. Different types of devises, specific, demonstrative, general, residuary. Good stuff. Abatement versus redemption. So abatement is something something has been diminished in value. Redemption means it's been deemed that it no longer exists. Talked about pretermitted spouses. Lapse and anti-lapse. Florida does have an anti-lapse statute. So if you devise a gift to Tommy and then Tommy's dead, it'll go to Tommy's heirs as long as they're a lineal descendant of the grandparent. So, this is one of the greatest PowerPoints that we've ever done because Marion got 100% and then I paid her good money to make a good PowerPoint and do a good presentation, and it's gotten great feedback. So that presentation is actually on YouTube. All the presentations that the ladies gave this administration, I put on YouTube. So Marion's presentation, the one Marion did with Emily for family law, and Rebecca's presentations on ethics and trusts. See, Rebecca's Florida trust PowerPoint. All right, and then the last thing to talk about would be Florida civil procedure. And I really appreciate everyone for staying with me. As you guys probably saw, I did do a 3-hour session with Gabby right before this started. So it's been a long day for me. And I have like 5-6 more students after this. But just like I wanted to show you, I don't really feel bad for you all for how hard you're studying because I work like this 366 days a year. And if you're going to be attorneys work harder than most. So it's not something that we should be feeling bad for ourselves about. It's something that we should be doing with integrity and discipline, and we'll get the job done. All right, last thing to look at would be her criminal procedure outline. And Barbara used to be a defendant, what would you call it? A defendant of the county in California. So she knows her shit. So chain of command is Florida Supreme Court, and then underneath that is the DCAs. Generally, the trial courts and circuit courts get the bigger things. Misfelridge, misdemeanors joined with felonies, writs, mandamuses, and juvenile cases. County courts get the leftovers, like smaller misdemeanors, municipal county ordinances, and first appearances. So you have a right to counsel usually in these different factors. It can be waived if it's knowing, intelligent, and voluntary, and they'll consider your education, prior experience, and complexity of the case, what kind of case is it, how is the defendant, and any mental conditions. So you can get pretrial release, right? For judicial integrity, safety of the community, and for them not to leave the jurisdiction if you're not a flight risk. Those are the reasons that you would get a pretrial release, but you wouldn't get them, which would be if you're in reasonable flight risk, you constitute a reasonable risk of body harm to others, you refuse to sign or identify yourself, you have no ties to the jurisdiction, or things like that. So everyone's entitled to pretrial release on reasonable grounds, except when you're charged with capital or life felony, or proof of guilt is evident, or presumption of guilt is great. So, right, these are the pretrial release conditions. You get your first appearance within 24 hours of the arrest. At first appearance, we have CARP 24, counsel is appointed, advice is given about the case, release conditions are set, and probable cause determination. If necessary, the paperwork is delivered. So the probable cause determinations, you get a non-adversarial one within 48 hours of arrest, and they could have 2 24-hour extensions for a maximum of 96 hours for the probable cause determination hearing if it's non-adversarial. If you are convicted of a felony for some defendants, you could get a adversarial adversarial preliminary hearing. If it's a felony, you've generally been detained and no charge has been filed within 21 days. And if that happens, then we have the 30-33-40 rule, which is no charges have been filed. You have to, by the 30th day, they have to release you by the 33rd, unless they show good cause, then they could extend it to the 40 days. Right, I like this. Nice Santa, what needs to be included in the information, the name of the accused, the intent to defraud, the caption, endorsement and signature, signature and oath, authority, nature of offense, time and place, and allegation of facts. And the docket entries will have docket entries, affidavits, and notice to appear. Those are different ways to get someone in, right? If it's a capital crime, we need an indictment. Non-capital felonies, it could be indictment or information, and then everything else could be, you know, indictment, information, or even notice to appear if it's very small. Joinder, you can join people in the same instrument if there's a link or a nexus. Let's see. Right, you can have a pretrial severance if it's appropriate to promote fair proceedings or necessary to protect defendant's speedy trial rights. A lot of really good stuff here. And then speedy trial, right? So if you demand for speedy trial, it has to be made within 60 days. You have to make the demand for speedy trial, and then they have 50 days from the demand to actually give you the speedy trial. If no demand is made, you have 90 days for misdemeanors and 175 days for felonies. If there's a misdemeanor and a felony, then you have 175 days. So if that time has passed, then they have to move for a discharge. They have to hold a hearing within 5 days. And then if there's no excusable delay within 10 days, you have to be discharged. There's a lot of reasons they could extend speedy trial limits. You have to disqualify a judge if they're prejudiced against the parties, if they're related to a defendant within the 3rd degree, if they're related to an attorney within the 3rd degree, or if the judge is a material witness in the case. For discovery, basic rule is reciprocity is the key. Within 15 days, the prosecutor shall disclose all this information. Things you don't have to turn over are privileged work product in anticipation of trial, the name of confidential informants, and limited surveillance information. Here's some random shit. Expert testimony. So Florida is the Daubert, not Fry standard. We've actually moved from Daubert to Fry back to Daubert. When I was a law clerk for my uncle in law school, we switched from Daubert to Fry, and I had to write this whole memo about what Fry meant, and then they switched right back. My memo was thrown in the trash. So sanctions, right? You can have sanctions for a lot of reasons. Pre-trial resolution, so plea bargaining, arraignment, that's where you plead guilty, not guilty, or nolo contendere. Your plea has to be voluntarily, right? Motions to suppress, different things. The voir dire, so 6 is the default for felony, capital cases is 12. No limit for cause. For preemptory challenges, 10 for capital case or life felonies, 6 for all other felonies, and 3 for misdemeanors. Verdicts must be unanimous for these criminal cases. Motion for a new trial within 10 days of the verdict. 3 strikes to increase sentence depending on how many convictions you have, right? If you've done more than 3 convictions, they can probably give you an increased sentence. To find death, there must be an aggravating factor to send someone to death. That's all we got. All right. I mean, you can really see Barbara deserved to get one of the top scores in the state when it came to Florida multiple choice because of how great her outlines were. Same with Joelle. And then Will's master outline, you know, this thing is as good as it gets. I have my Florida essay guidebook. I have all the resources you need. I really don't feel like there's any reason why everyone in here can't tie up some loose ends this weekend and crush the exam on Tuesday. So as you may or may not know, I will be in Tampa. Look for the really handsome guy with the funny dog jokes, and I'll wish you all well. And then Wednesday night after the exam, we have a reservation at American Social, so we can talk about anything but the bar. I really, really appreciate everyone for sticking this out with me. I know it was a long class today, but I really wanted to make sure we left no stone unturned. This is the last class for Florida. I do have one class tomorrow at 11 o'clock for MBE, but if I don't see you or hear from you before the test, just be confident in yourself. I really believe in each and every one of you, and I'm wishing you the absolute best. Thank you very much.